What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And, hey, last night got a little, loud and ranty and great. I don't know, maybe it wasn't great. But it was fun. That's, whatever it was fun for me. So tonight, we're going to go ahead and pick up, I think, where we left off. I think. Roughly where we left off. Somewhere in here. Where we're not even this far. Oh, man. That's great. Let's see. I just got to find it real quick. I thought we were a lot farther than that. That's whew. Yeah, I am okay. Everything is fine. Today was a little interesting. I managed to stave off the negative effects of a hangover in my head, but not in my stomach. Not in my stomach. And I know I did shave the beard. I apologize. It'll come back. But, couple things. One, I have court coming up, so I was going to have to shave anyway. And two, the mustache starts to go into my mouth, and then I'm like chewing on it with my lower lip, and it's awful. It caused me jaw pain, so I'm not a big fan of that. But anyway, so I think it was around page 18. Yeah, I think so too. Somewhere in there. Somewhere. Yes, there we go. Business is fundraising. That looks kind of familiar. Pockets a lot of money sent in by panic donors. Buying the smear campaigns. Yeah, I think this is the last one we read. Oh, wait, no. Here we go. This one looks fun. I think that might be it. All right. Yeah, I think it's around here. Right around this area. That's where we'll pick up. Now, what I have to do is stall as much as possible before getting into the document. One thing. Oh, thank you, Bagel Goose, for covering my bald face. Siren Jag says, I wish I could be a fly on the wall outside the door of the bathroom just to hear the screams of pain and regret when all of that capsicum from the sriracha hit Rackets' colon like a bullet train. Actually, I'm very adept at dealing with spicy food, and the spiciness of that liquor is nothing. It's not the spiciness. It's awful because it's just cheap vodka, and the spice isn't really a problem. It just doesn't taste good. Just doesn't taste good. And you probably didn't want to be a fly on the wall anyway. It's still unpleasant. But not from the spice. So we stopped before the SPLC is hypocritical. Okay, I think it was on. Yeah, I know I talked about George Wallace, and I think it's this this bullet point and then the succeeding ones that we need to cover, and then keep going. What was I gonna say? Oh yeah, I wanted to let you guys know that of course this is the live stream, and live shows have dynamics to them that some people enjoy, and then dynamics that some people don't enjoy. Okay? That's fine. However, just know that once I'm done going through the document live with you guys, I will be releasing a condensed video summarizing the lawsuit and encapsulating that. So if you have problems with like the pacing of a live stream, if you don't like the banter and the joking and the the fact that, you know, I have more interactivity with the chat or whatever. I get it. That's cool. Cool. Not a big deal. Just check out the summary video when that comes up. If you like all the nonsense and the craziness and me reacting and getting heated up over it, then check out the live streams. That's why I try and cover things from multiple angles to make more people happy and make the content more accessible. So, there you go, guys. That's how it is. So we're going to go ahead and get back into this document. Is there anything else I can do that I need to say beforehand? Of course, you can do justice chats. You can do super chats to interact and ask me questions. I am not drinking any alcohol tonight because my liver needs a day off. It actually called in this morning and said, hey, I'm not coming to work tonight. So I've got apple juice and tea. We're going to go through this. And then maybe we can compare rage levels. I don't know. But here we go. Where are we? Alas, these days, the SPLC is mainly a fundraising machine, said Gail Hirio, a U.S. Commission on Civil Rights member who voted against Friday's resolution. The more it can persuade its donors that hate groups have penetrated every nook and cranny of American society, hashtag Me Too for America, I guess, the more money it can raise. The SPLC has no credibility with anyone on the left or the right who is familiar with its methods. Now, we've got a couple more good quotes here. Morris Dees is a con man and fraud, and I and others such as U.S. Circuit Judge Cecil Poole have observed and has been documented by John Egerton, Harper's The Montgomery Advisor in its Charity of Riches series, and others, the positive contributions Dees has made to justice, most undertaken based upon calculations as to their publicity and fundraising potential, are far overshadowed by what Harper's described as his flagrantly misleading solicitation for money. He's raised millions upon millions of dollars with various schemes, never mentioning that he does not need the money because he has $175 million and 2 Poverty Palace buildings in Montgomery. He has taken advantage of naive, well-meaning people, some of moderate or low incomes, who believed his pitches and give to his $175 million operation. He spent most of what they have sent him to raise still more millions, pay high salaries, and promote himself. Because he spends so much on fundraising, his operation spends $30 million a year to accomplish less than what many other organizations accomplish on shoestring budgets. That's from Joseph Farah, May 30, 2012 article in WorldNet Daily, quoting a 2007 letter from Stephen Bright, professor at Yale Law School and director of the Southern Center for Human Rights, to the dean of the University of Alabama Law School. So I remember reading that now. I think I remember reading that now. But yeah, I mean, the whole point of this is that the SPLC for a long time, has been a sham. I mean, it's come to our attention that it's more of a sham recently with because they've gotten increased power. The increased ability to shut people down has increased their exposure. Of course, the media, the greater, I'll say, awareness of obvious media bias that's grown over the past decade, really, like exploded over the past decade. That has really highlighted goodness gracious, has really highlighted the level of power and influence these types of organizations have. And the fact that they're just sucking down other people's money is, of course, absolutely disgusting. I got to get the Stream Me chat pulled up because I don't know if it's even happening. There we go. So yes, of course I am now, and this will probably be forever, unless something weird happens. I am simulcasting on both YouTube and Stream Me. Watch on the platform of your choice. I try and monitor both chats as much as possible, and the Stream Me chat should feed in to the feed, but there seem to be issues with Stream Me's connections. I don't know, but I know the archive function is still not working over there. They've got one video archived, but the other one, what am I looking for all my stuff? The other video archive just didn't work. And yes, my archive videos option is checked. Yes, guys, I'm not that inept. It's not me. There's some issue on StreamMe with the archiving feature. I don't know. They told me they're looking into it, but hopefully that gets fixed. But this will be simulcast there. So if you don't, if you want to watch over there, watch over there. They've got some different features than YouTube. But yeah. So just to make sure we're in both places. All right. Kozer, thanks for the test chat from StreamMe. It is there. Yeah, it is lonely over there, buddy. I can tell. Okay, back to this document. Need to make a StreamMe to YouTube chat link. I don't know how to do that. Maybe in the I think you guys can do. I think you can join the Restream chat. I'll look into that. If there might be a way to chat into Restream and then chat to both. But I don't know. I got to figure it out. Anyway, guys, let me get back to the document. Wouldn't want to tangent all day. Maybe. The Southern Poverty Law Center is a thriving business. Its business is fundraising, and its success at raking in cash is based on its ability to sell gullible people on the idea that present-day America is awash in white racism and anti-Semitism, which it will fight tooth and nail as the public interest law firm it purports to be. That might lead a skeptic to wonder why it spends little on litigation and why Mr. D's pockets a lot of money sent in by panic donors who buy into the smear campaigns against organizations or prominent individuals who question racial preference programs. To me and to other observant conservatives, the Southern Poverty Law Center is a clever scam, relentlessly cultivating for profit the fear that this nation is filled with Klansmen and rife with people eager to perpetrate genocide. And yeah, if you spend an hour on Twitter, right, you'll find people saying that there are real Nazis who will really commit genocide everywhere. I got into this. There was some dummy on Twitter arguing about PewDiePie, saying PewDiePie was an actual Nazi because of his Fiverr joke that he did. You know, the one that got him in trouble with Wall Street Journal, because the Wall Street Journal, apparently that's their job to police YouTube now. But and he's like, yeah, he promoted a Nazi channel or whatever, so he's literally a Nazi. And it's like, you know, for all the Nazis you guys are calling out, no one's out there actually getting genocided, and no one's out there even trying to genocide anybody. And if you are trying to genocide, you're not doing a good job of it, right? Like, where is the genocide? Not that we want it, but it should be everywhere according to these people. I'm sure that'll get clipped out of context. Oh my gosh. So it's just this wild thing. It's like, where is all of this? Bagel Goose asks, why does anti-Semitism get separated from racism? Well, I mean, that's a good question, because it isn't really about religious Judaism. It's about ethnic Jews, right? Like that's anti-Semitism, or that's what I believe encompasses anti-Semitism. So why is it separated from racism? No idea. Well, probably because the SPLC is racist. Sean Salas says, do the next stream as a blackface lawyer. Probably not. But yeah, I want to talk about, there is a difference between anti-Semitism and racism. There is, but it's not from the perspective of the prejudicer. Okay, it's from the marketing campaign around each one. Anti-Semitism has the best marketing of any public action group I've ever seen. Is there anything else where you can accuse someone of racism and they can kind of endure it for a while? If you accuse someone of anti-Semitism, it's tough. It's tougher. It's tougher than any other racist charge. And it's weird because what's the distinction? Like, what's the distinction? There are exterminations of many different races in many different places and on different scopes and scales. The Holocaust, of course, terrible. Any mass atrocity, loss of life is terrible. But that said, in context with other massacres, other Holocausts, other genocides, it's up there. It's right around the horrible mark with the rest of them. But why does anti-Semitism get this extra level of marketing where not like an anti-Semitic joke means that someone will then go kill all the Jews? I don't understand that. But they're very, very good at marketing that. Whoever's job it is to go ahead and make sure that there are no anti-Semites is better at their job than whoever it is to make sure there's no hatred of Asians, for example. Like, they have the best marketing team. I don't know. Andrew Gluck says the name Wall Street Journal is problematic in 19. So, anyway, it's just, it's such a weird thing. Like, if you make a racist joke, maybe if you make a racist black joke, it means that you're going to put black people back into slavery. I don't know. I don't understand how these people think, because it's so ridiculous. So who knows? I guess the summary of that is, I'm not seeing the genocide that I keep hearing is happening. So that's for better or worse, I guess. Have you seen that doc when a European newspaper did a documentary on the ADL and they wanted to follow up on a hate crime? No, I haven't seen that. I don't watch a lot of documentaries because not my thing. The SPLC is hypocritical. This is paragraph 31. The SPLC does not apply the same standards to itself that it uses for the hate groups it defines. One of its favored smear tactics is to proclaim links or ties between disturbed individuals who commit violent acts and hate groups based on highly tenuous connections between the individuals and the groups. For example, a November 2015 article on the SPLC website that blazons the headline, quote, "Former National Alliance supporter charged with murder and evidence tampering," describes a man named Collins who was charged with murdering a man named Kelly. Well, I think his parents did him in there. Collins is described as a National Alliance supporter because he once bought literature from the National Alliance. No connection whatever is shown in the article between that purchase and Kelly's murder. Nonetheless, the SPLC links the murder to the National Alliance. And of course, this is how it goes, right? Like, this is every bombing, every shooting, any mass shooting. If they once watched or listened to a Rush Limbaugh episode, Rush probably caused him to shoot people. All of that. I'm pretty sure Ben Shapiro has driven several people to murder people. Oh yeah, that one guy. There's that whole thing about who was it? Who's that dummy? Put out a video. There's some dumb YouTuber. What's his name? I don't know. Someone linked to me this video, and it was like a bunch of clips of Ben Shapiro talking about Muslims murdering people, and then some guy shot up like a mosque or whatever and listened to Ben Shapiro, and then it was Ben Shapiro's fault that this guy shot some Muslim people. So, because that's how it works, right? This tactic is very, very effective, I guess. Was it the Young Turks? It might have been the Young Turks. No, I think it was someone else. Yeah, Legal Eagle. What's it? Legal Eagle thinks Ben Shapiro is a genocidal maniac. Saavedro says Star Trek Discovery was sued for plagiarizing the video game Tardigrades. Thoughts are that's a very, very interesting lawsuit. There's a big development. I have DM'd Anis Abdin, I think is how you say his name, the creator of the video game. I was hoping to get him in an interview, but when I talked to him at the time, his legal counsel didn't want him going out and doing media appearances about the case. So I'm hoping as that trial progresses that we will get a chance to have him on the show. I do want to cover the lawsuit, but I would like to have, if possible, my friend Stephen Birch, who does IP law, to help me talk about it, because I think the case is really interesting. And if there is a good case, I would like to make sure and present it as a good case with some more expertise than I have, because I think it looks pretty good. And them moving into discovery, at least a limited discovery, moving past the initial motion to dismiss, is a big step. That's a big step. And I think that is indicative that there's more of a case here than a lot of people thought at first. So I will be covering that probably soon, but I want to get a good assist from my buddy Mr. Birch to help me out with that one. And don't mind me, yes, that's the blog post is what I'm referencing. All right. Contrast this. So that was about linking the murder to the National Alliance. Contrast this to the 2012 Floyd Corkins incident, in which Corkins, inspired by the SPLC's designation of the Family Research Council, an American conservative Christian group, as a hate group, and using the SPLC's website Hate Map for approximate directions, walked into the FRC's offices with intent to kill as many people as possible, or many people as he could, and did shoot and badly wound a security guard. The SPLC, however, not very good at shooting, apparently. The SPLC, however, decries as outrageous any attempt to tie or link it to Corkins' murderous rampage. Now, to be fair, his murderous rampage wasn't very murderous or rampagey. He shot a security guard, which is, you don't want to be the guy getting shot, but no one died. So that was good. That was good, but let's not be too hyperbolic here. In short, if a person buys literature from an SPLC hate group and then commits a crime, the SPLC links the person to the hate group, even if the purchase of literature had no connection with the crime. But if a person explicitly uses the SPLC hate group designation and hate map as a blueprint for murder, no links or ties there. Right. All right, the SPLC's double standards were also prominently displayed with respect to James Hodgkinson's murderous attacks on conservative congressmen in June 2017. The SPLC acknowledged that Hodgkinson was consumed with anti-Trump anger, but omitted to acknowledge that the SPLC had aggressively fomented anti-Trump anger for well over a year prior to the attacks. Filing in April 2017 by the Federation for American Immigration Reform, FAIR, with the Secretary of the Treasury, details well over 100 instances in which the SPLC viciously attacked Trump in the period from June 2015 to July 2016. Hodgkinson was a follower of the SPLC, having liked it on Facebook, yet the SPLC accepts no responsibility for Hodgkinson's actions. One commentator described the SPLC's disclaimers as follows: SPLC's president, Richard Cohen, naturally and predictably disavowed any influence or responsibility whatsoever, though it has been stirring up hatred by demonizing groups like FRC and the American Family Association for years. They're like a guy who gives gasoline and matches to a teenager and then feigns innocence and utter shock when the kid burns down a house, which is unfair. Very unfair. Kids don't burn down houses. Saavedro, for how many eternities will the Damore/Google lawsuit be in limbo? Many eternities. Damore is his lawsuit is suspended. He is in arbitration, or he will go to arbitration. Whether or not we will ever hear about the answer to that is anyone's guess. Anyone's guess. I don't know. Oh, excuse me. I don't know if we'll ever see the results of that. Often arbitration results are secret. Often the discovery in arbitration is secret. This is why Google does it, of course. Why any of these big countries or companies, why any of these big companies do that is because they get to keep private what would otherwise be very public. So the class action is still going. I haven't seen any updates on it in a while. I have a bot that watches the court document uploads for it, but it's just kind of in limbo. The only class that still has a suit against Google that is moving forward, to my knowledge, is the prospective employees who are white or Asian males who were not hired. They are the only people left with a lawsuit at this time. All right. There's something else I was going to talk about. Oh, but there are other interesting things happening. Sorry for the sidebar here, but I've had a couple conversations with a man known on this channel a little bit as Vox Day, and Vox Day, of course, has a publishing arm as part of his business that publishes comic books, and the comic book Alt Hero Q, which was funded through Indiegogo to the tune of like $130,000, was the payment was promised to be made to them, and then Indiegogo shut down the campaign after promising to pay out the money and refunded everybody's money. So my understanding is that Vox is entering into their arbitration. I'm hoping to interview him about that at some point in the future as things start to go. From what I've talked to him about the case, I think it's very interesting. I think he's got some... because of how it played out, this is the key to this. Because of how Indiegogo handled the situation, right now, Vox is in a very unique position where otherwise, if the similar sort of thing happened to anybody, it wouldn't work out the same way. But because of the steps that Indiegogo took, they might have opened themselves up to liability. And so this will be an interesting test case because if he is victorious on this, it will definitely change Indiegogo's policies on how they cancel projects, because they made some missteps on this one that I think maybe open them up to liability. So we'll see. That's an arbitration process, but we may be able to get some info out of that simply because I may be able to get info from the person inside for whatever he's able to disclose. Obviously, if he can't disclose it, we're not going to talk about it. But that keep an eye out for that. I think that'll be very interesting to see. And we've got to start winning some of these suits. Damore, I would love to have an inside information on Damore, but unfortunately I don't right now. Always working on it. So, yeah. Number 34, the SPLC's demonizing of the political scientist and author Charles A. Murray also manifests the SPLC's double standards. Murray has disclosed that he has been subjected to threats and physical violence because of the SPLC's characterization of him as an extremist, a characterization permeated with false statements. The SPLC, however, never accepted any responsibility for the physical assaults on Murray. SPLC uses the word poverty in its name, but in reality is fabulously wealthy. Fabulous. Much of that wealth finds its way into its luxurious offices, which Stephen Bright, whose credentials as head of the Southern Human Rights Center are impeccable, characterized as poverty palaces. and into the sumptuous lifestyle of Morris Dees, who has been married at least 5 times. That sounds like too much work. Speaking of that, Jeff Bezos is getting divorced from his wife. The richest couple on earth are getting divorced, so that will surely make one of the richest or most expensive divorces in history. And Bezos will move from the wealthiest man in the world to probably not the wealthiest man in the world after that divorce. That'll be really interesting, I think. But the other thing that would be really interesting is that divorce records are often public. So we might actually get to find out some interesting info from Jeff Bezos. Okay. In reality, although the SPLC has poverty in its title, its aims have little to do with alleviating poverty. I didn't think they had any aim to alleviate poverty. As defendant Potok acknowledged in a 2008 interview, in the 70s, poverty law was actually the phrase. It was a phrase used that just applied to essentially civil rights law, to kind of human rights legal actions. I know a couple years ago there was a big discussion internally at the SPLC. Should we change our name to something else? People think, that it's all about sort of defending poor people, and that's not really exactly what our mission is. Good Lord. Is this guy a lawyer? Learn to speak. I mean, we saw him, right? He looks like a little Muppet. By that time, people knew the name so well, we made, I think, the obviously right decision not to change the name. What just a terrible sentence structure. By that time, people knew the name so well that, we made, I think, the obviously right decision not to change the name. Ugh. The SPLC postures itself as a defender of African Americans, but has been and remains subject to well-grounded criticism regarding its own treatment of African Americans. A 1994 that's because they're in Alabama, so they're racist. A 1994 series in the Montgomery, Alabama Advertiser, for example, noted the lack of African Americans in the SPLC's management, or the complaints by several African Americans of poor, indeed racist treatment by the SPLC. Quote, of 13 black former center staffers contacted, 12 said they either experienced or observed racial problems inside the law center. 3 said they heard racial slurs. 3 likened the center to a plantation. And 2 said they had been treated better at predominantly white corporate law firms. According to internal memorandums, staffers have accused Morris Dees, the center's driving force, of being a racist, and black employees have felt threatened and banded together. And for 47 years, up to and including 2017, there have been no African Americans among the SPLC's highest paid officers. Of course not. Of course not. There never are. These organizations all put the white in white knight. Like, none of them want to hire black people. Not a single one. Oh my gosh. It's all a bunch of people motivated by some moral superiority and then some level of guilt over something that they probably had nothing to do with, and their own racism. I mean, that's what drives it. Why do I look weird? It's probably because my beard fell off. All right. SPLC has an anti-Christian bias. I mean, maybe. The SPLC's definition of a hate group is so permeated with subjective criteria that the SPLC can and does use it selectively to support its own political agenda. As George Yancey, a professor at the University of North Texas and an African American, noted in his recent study, as our society became more politically partisan, SPLC cemented its position as speaking for those with progressive political and social attitudes, rather than developing into an objective clearinghouse for the identification of hatred. And let me stop you right there, sir. We don't need an objective clearinghouse for the identification of hatred. You don't have to have anybody point out hatred. There's no cause for it. Because if it's hatred, you know, like you see that and you get to perceive the hatred. Or maybe you don't perceive hatred. Because maybe to someone else, it's not. So we don't need any objective clearinghouse for hatred. We don't need any clearinghouse. Subjective, non-objective. It doesn't matter. We don't need it. We don't need it. People can decide for themselves what is hate and what isn't hate. When did we abdicate our ability to discern and judge onto an organization? Why do we ever say that this was something we wanted? Did anybody say that? I don't think anybody actually was like, you know what we need? Yes, I am aware of the countersuit against Lindsay Shepherd. This is the woman from Canada, the college assistant professor who I believe recorded two I guess more senior professors or whatever berating her for her curriculum. I am aware of it. I haven't read up on the suit, but I have read about it. Or I have, let me see. I haven't read up in depth on the suit, but I have read about the suit existing. How's that? How's that? All right, so we don't, yeah. Objective clearinghouse for the identification of hatred. No matter where the source of that hatred may develop, SPLC has become a useful organization for progressives to legitimate their battles against conservatives. To legitimate. That's a weird way to say that. Legitimate their battles against conservatives. Since conservative Christians are categorized as opponents, there is little, if any, incentive for SPLC to recognize hateful expressions against Christians, because doing so actually works against the social vested interests of the group. Another example of the SPLC's anti-Christian bias was noted by Peter Pappas in his book Fanning the Flames at page 192. Quote, the SPLC's anti-Christian agenda is betrayed as much by the groups it has chosen not to list as by those it lists. The SPLC's anti-gay list, which includes numerous Christian organizations, does not contain the name of a single mosque or Muslim organization. Not even one. Maybe the SPLC is unaware of how Sharia law deal with homosexuals. The Islamic Society of North America calls homosexual relationships a deviation from the laws of Allah. ISNA is not listed as an anti-gay hate group on the SPLC site. Council on American Islamic Relations, or CARE, is an organization that aims to implement Sharia law, an Islamic legal system that punishes homosexuality with death. CARE is likewise not listed by the SPLC as an anti-gay hate group. See also Awad bin Hazim, Muslim chaplain and adjunct professor at Vanderbilt, acknowledging and defending Sharia law that requires death for the gays. The SPLC has not criticized bin Hazim. Yeah, and that's another. It's just, this isn't limited to the SPLC. I mean, I'm glad they're getting dunked on, right? In this suit. I'm glad all of this is being called out. But this is just the way of the day, right? For some reason, Islam gets a pass on all of the things that more traditional Christians don't get a pass on. Even though they share ballparks of the same views. I don't know that many modern Christians call for the death of homosexuals. I'm sure there are some, but I don't know that it's very many. I do know that it's not uncommon to hear it coming out of Islam. So, all right. Alan, this is about Alan, Gary Allen. Alan comes from a broken home. Constant changes of residence in his youth, plus problems in his family life, engendered in him a solitary, cautious, and reticent nature, highly prone to keeping his thoughts to himself. As an at-risk teenager, he was fortuitously introduced to the local University of Chicago Great Books discussion program in the Colorado town where he was then living. Reading the great books became Allen's refuge, helping him avoid the drugs and crime that entangled many around him. It ingrained in him the attitude that no idea, however widely accepted, was sacrosanct. Footnote 1. To its credit, the University of Chicago continues to this day to support and defend open discussion on controversial issues. Well, good. At least there's one left. That was an article from 2017, though, so it's probably gone now. Saavedra says, any interesting docs on Majid Nawaz's settlement with the SPLC? No idea. No idea. Not to my knowledge. It's because modern Christians does not decapitate you. That's probably true. Maybe that's a motivator. Maybe keeping heads on is the motivator. Maybe it's Charlie Hebdo, right? Like maybe that's why the SPLC, maybe they're just scared that if they go ahead and label a mosque as a hate group, that they'll come up and someone will come in and shoot up the whole place for besmirching the prophet. Peace be upon him. In 1974, Allen graduated from the Colorado College with a degree in philosophy. He was accepted into several graduate programs in philosophy, but unable to pay tuition, did not attend. Seeking to raise money to attend law school. In 1978, Allen joined the Army as an enlisted man. In September 1982, having completed his term of enlistment, he was discharged. He had served honorably and had been promoted twice. In the fall of 1984, Allen began law school at the University of Maryland. He was a diligent student and did well in law school, finishing near the top of his class and serving as executive director of the Law Review. In 1987, following graduation from law school, Allen clerked for Chief Judge Robert Murphy on the Maryland Court of Appeals. 1988, Allen began as an associate in the litigation department of what was then Piper and Marbury, now DLA Piper. He became of counsel in that firm in 1998. He retired from DLA Piper in December 2015. By 1991, Allen had been admitted to the Maryland Bar and the bars of the Federal District Court for the District of Maryland, the Fourth Circuit Court of Appeals, 10th Circuit Court of Appeals, and the U.S. Supreme Court. In 2013, he was admitted to the District of Columbia Bar. In 2017, he was admitted to the bar of the U.S. District Court for the District of Columbia. He remains in good standing in all these bars and many other bars along the way. Barrich, the Intelligence Project, and the SPLC operate a vast surveillance network whose surveillance has included combing through pleadings to review any case in which Allen was involved, and Barrich has specifically boasted that she and the SPLC have been, quote, watching Allen like a hawk. Accordingly, Barrich, Potok, and the SPLC, including the Intelligence Projects, were well aware at the time of their publication of the August 17, 2016 article that Allen had been active in pro bono matters, often on behalf of African Americans. For example, here's my list of virtues. Are all legal filings so wordy? Depends. Really depends. This part of it, he's setting, I mean, they're building the narrative, right? They're building the narrative. The SPLC, extremely wealthy. The SPLC, duplicitous, has double standards, scamming people out of money, abusing its tax-exempt authority, abusing the public perception that it puts out to go after people who don't have as much help. This guy, broken home, hardworking man, enlisted, served his country honorably, admitted to all these different bars, and they don't have a problem with him. Just a guy trying to do good work for some poor black people, and SPLC hates him. It's about building the narrative. So this part of the lawsuit's gonna be wordy. Gonna be wordy. See, for example, as the SPLC, including the Intelligence Project, knew, remember, guys, they have a vast surveillance network. They're watching him like a hawk. That's important to the narrative. The narrative is they're omitting the things that they know that he's done that would look good. They're omitting that and focusing only on these past events Long time ago. Notice he didn't include the past events yet. He's going to bury that down. His past event was his association with the National Alliance, I believe, which is labeled as a white ethno-nationalist group, maybe. I don't know. I don't know anything about them, but I'm guessing that's what's going on here, and I think that's what I read. But we'll see as we go. So as they knew, Allen devoted substantial time, over 100 hours, pro bono, to the defense of Arthur Lloyd, an incarcerated African-American federal deputy marshal who had shot and killed a white Navy seaman in Stowers versus United States. Wrongful death civil case following Lloyd's criminal conviction for manslaughter. Judge Peter Mesite, who had requested only 10 hours from Allen, recommended Allen for, quote, an admirable job in representing Lloyd, or commended Allen for an admirable job in representing Lloyd and his, quote, considerable efforts on Lloyd's behalf. As the SPLC, including the Intelligence Project, knew, Allen, working with Professor Michael Millman of the University of Maryland School of Law and Michael Bachma of DLA Piper in 2015, prepared and filed an amicus brief in the Court of Appeals of Maryland, the state of Maryland versus Wayne, on behalf of the Maryland Law School's Clinical Law Program and Social Work Services Program and the Maryland Restorative Justice Initiative Incorporated, and in support of the appellee Peter Sutro Wayne. The Wayne case raised the issue of overruling Unger versus State. The amicus brief opposed this. Overruling Unger would have had dire implications for hundreds of African Americans sentenced to life in prison in prior decades. September 2016, after the August 17, 2016 article by Birich in the SPLC described in this complaint, Professor Milliman sent Allen an unsolicited email stating, Glenn, I'm writing to thank you for your great work on Unger. For over 200 African Americans who were sentenced to life in prison in the 1960s and 70s on convictions for murder and rape. Many of these convictions were flawed, in significant part because of race discrimination. Again, I really appreciate your superb help and, more importantly, the many good men who are coming home in part because of it. Thank you. P.S. And yes, I have seen the press. I trust instead the facts I see before me. Thanks again for your great work. Mike, life is reborn every day. This is, of course, the American, or not American. This is the reality for the average person, right? Someone gets painted as awful, lambasted, tarred and feathered, completely characterized in a specific negative way. People hate them, but the people who know them are always like, wait, I mean, really? Like, is that what it is? There's always... The reality is that there are just people, right? And even if they do or say horrible things to you, when you're outside of any context, when you're looking in from the outside, you don't get to see their fruits. Like, you don't get to know if they're actually terrible people unless you're around them. You can't judge them based on a word or an act or something. It doesn't work that way unless they just murder someone, I guess. Okay. As the SPLC, including the Intelligence Project, this repetition, very important, of course, knew or could have easily learned. That one changes a little bit. For 4 years as part of a DLA Piper pro bono program, Allen was the mentor for a fatherless African-American youth named DeAndre Johnson. Goal of the DLA program was to assure that at-risk African-American young people graduated from high school. Allen and the DLA program succeeded with respect to DeAndre, who graduated from Northwestern High School. Allen's efforts on behalf of DeAndre included visiting his high school, encouraging him to go out for the track team, and trying to find work for him at Walmart. As Birich and the SPLC, including the Intelligence Project, also knew, because it was described in a local newspaper, Allen gave money to a Native American scholarship fund that all went to Elizabeth Warren, created to honor Allen's grandfather, and in 2012, as shown in the following paragraph, presented the scholarship award to a Native American youth. That's not Elizabeth Warren. Allen retired from DLA Piper on December 31st, 2015, after more than 27 years of service at the firm. By this date, DLA Piper had become one of the largest law firms in the world. Allen, wanting to stay active as an attorney, created a website. The website included many testimonials from his former colleagues, including many colleagues with whom he had worked for over 2 decades and who now occupied high management positions at the firm. Testimonials praised Allen's character, legal abilities, and accomplishments. Glenn and I worked closely together for many years. He is one of the best critical thinkers, legal writers, and problem solvers I have ever known. Glenn Allen is a lawyer's lawyer. He's one of the best problem solvers with whom I have worked in my legal career. He welcomes and solves complex legal problems which elude others. Glenn enhanced our intellectual firepower and made us all more effective advocates. I worked with Glenn for decades. No one writes a more persuasive brief. Glenn has the rare ability to find the needle, which is the winning argument, in the haystack, which is a messy combination of facts and laws. Glenn is one of the smartest lawyers and best writers with whom I have had the pleasure to work. Glenn was the colleague whose number I kept on speed dial for when I needed help solving the most difficult legal issues. Glenn Allen is an exceptionally fine lawyer. He can be relied on as a strong advocate who knows the law and how to use it effectively. Glenn is at the top of my ranks of respected, able, and effective lawyers. Good job. Good job. What? Why? Who am I ignoring? Who am I ignoring? Hell? Hi, Hell. What's up, buddy? I didn't mean to ignore you, bud. Anyway, here we go. So yeah, a bunch of praise. Again, he's padding his side of the issue. This is the SPLC. They're terrible, but look at me. I'm great. 2015 to 2016, Allen participated in the formation of the American Eagle Party. American Eagle Party welcomed persons of all races, ethnicities, and religions. Its platform had 5 basic goals: end America's involvement in foreign wars and occupations, stop illegal immigration, reclaim constitutional rights and liberties, restore America's economy, and enable media alternatives. In February 2016, Allen met with George Nilsen, Baltimore City Solicitor, sorry. Mr. Nilsen had been a partner at DLA Piper for many years before becoming city solicitor. He and Allen were on cordial terms. Allen had then, and has today, the greatest admiration for Mr. Nilsen's integrity, creativity, prowess as an attorney, devotion to the city of Baltimore, and affability. As a result of that meeting, Allen agreed to come work for the city of Baltimore Law Department as an independent contractor at a fraction of the salary he'd been earning at DLA Piper. One important component of the discussion was that Allen would have a high probability of succeeding William Phelan as the chief city solicitor in charge of appeals upon Mr. Phelan's retirement, which was anticipated to occur within the year. Allen began work for the city of Baltimore in February 2016 in the position of assistant city solicitor. He continued working in this capacity until terminated as a result of the SPLC's August 17, 2016 article. Allen worked zealously and well for the city. He received no complaints and his work was often praised. Although as an assistant city solicitor, he occupied the lowest rung on the city solicitor's echelon of attorneys, he greatly enjoyed the work as he was able to work toward the defense and betterment of Baltimore, his adopted city, which he did with pride and enthusiasm. And if you don't know anything about Baltimore, go watch Hairspray, a musical about a fat chick with a fat dad for a mom. He was on cordial terms with his colleagues, worked cooperatively and respectfully with all of them, played on the city solicitor's softball team, and participated in 5K runs for charitable purposes with his colleagues, as shown on the following photograph. Good job. Good job, old guy. I think he's this guy over here. My little pointer is going over his face. Groom him a little bit. He's now on the Sweetie Squad. He's been groomed. One of the cases on which Allen worked, albeit briefly, was Burgess versus Baltimore Police Department, a federal case involving multi-million-dollar claims against the city of Baltimore Police Department for wrongful conviction. Although the only pleading in Burgess on which Allen worked significantly was a motion to bifurcate, which the court granted, he was fully prepared to provide his competence, 27 years of litigation experience, and zeal within ethical limits on behalf of the city's defense, and would have done so had the SPLC and Intelligence Project not orchestrated his firing on August 18, 2016, partly on the incoherent rationale discussed in paragraphs 80 to 86 that it was somehow improper that Allen was working for the city on the Burgess case at all, even if he was doing competent and ethical work. On November 21st, 2017, about 15 months after Allen's SPLC orchestrated filing, the city lost the Burgess case badly. Federal jury awarded the plaintiff $15 million, one of the largest verdicts ever awarded in cases of this kind. The SPLC participated in the theft of confidential National Alliance documents. Ooh. So that's the parties. That's important, of course. Now we're going to get into the allegations a little more, a little more concretely. Dr. William Pierce, founder of the National Alliance, served as its chairman until his death in 2002. After his death, Eric Glebe succeeded him as chairman. On October 2014, Glebe resigned and Will Williams became chairman. Bill. What up, Bill? Williams, on assuming the position of chairman, was aware that the National Alliance's office building in West Virginia had no National Alliance employee living in or near it to protect and maintain it. And he was generally aware that the National Alliance was in financial and organizational disarray. Needing an Alliance employee on the property, Williams lived in Tennessee, and also needing a more precise assessment of the Alliance's financial condition, in December 2014, Williams hired Randolph Dillaway, an accountant, pursuant to an employment agreement. Dillaway was tasked with living on and maintaining the West Virginia property and organizing and assessing the financial and business records on the property. From the outset of the relationship, Williams made clear to Dillaway that he would be given access to confidential documents that must remain confidential. Indeed, this fact was obvious. Moreover, the employment agreement that Dillaway signed contained extensive confidentiality provisions. The relationship between Williams and Dillaway was marked by accelerating discord during the approximate 4 months that it existed. Williams, a decorated Army Special Forces officer in Vietnam, found Dillaway ineffective and insubordinate. This discord reached a boiling point on May 3rd, 2015. On that date, after Williams had traveled from Tennessee to the West Virginia property to discuss Dillaway's problematic work performance, Dillaway was aggressive and belligerent towards Williams. When the two angry men were on the verge of a fist fight, Dillaway noticed that a female National Alliance employee who was present with Williams at the confrontation had a pistol, which she never brandished. Dillaway left the scene hurriedly on foot. Reaching a house about a mile distance, he called the local sheriff. Meanwhile, Williams and the female employee, having determined that Dillaway had stolen National Alliance property and been preparing to steal more, had also called the sheriff. Dillaway returned to the National Alliance office with two sheriffs, in the presence of both of them and a forest ranger who had also arrived on the scene. Oh, thank God for the forest ranger. Is there a fire in here? Is there a fire in here? Fire out there? Fire anywhere? No? Let's go find one. Who had also arrived on the scene acknowledged that he had destroyed confidential National Alliance records on a computer with criminal intent. He was permitted to leave the National Alliance property in an old pickup truck, which he was allowed to load up with what the sheriffs and Williams assumed were his belongings. One of the sheriffs admonished Dillaway to leave and keep going. Going out of here! It's a country roads time. Unknown to Williams, Dillaway had secretly taken with him, had stolen, numerous thumb drives containing thousands of confidential National Alliance documents that Dillaway had been surreptitiously and improperly scanning for some time. These and any other documents Dillaway stole will sometimes be referred to in this complaint as the Dillaway stolen documents. You had the opportunity, Glenn. You had the opportunity. You have Dillaway documents. You had the chance. You could have referred to him. You could have been funnier in this document, buddy. According to a May 20th, 2015 article published on the SPLC website by the SPLC's intelligence project entitled Chaos on the Compound, described further in paragraph 72 to 75, Dillaway contacted the SPLC on May 6, 2015. That contact obviously included turning over the SPLC and the intelligence project the Dillaway stolen document. Sorry, Gene Agri Penguin. Sorry to keep you up. As the May 20 article makes repeated disclosures of and references to confidential National Alliance documents, including documents protected by attorney-client privilege. The contact involved interstate use of mail or wire services through telephone or internet communications to coordinate Dillaway's transmission of the Dillaway stolen documents to the SPLC, an intelligence project in Alabama, plus, in all probability, the transmission of the Dillaway stolen documents to the SPLC and intelligence project via the U.S. mail or other interstate carriers. The intelligence project, including Barrick and Potok, and SPLC knew these documents were stolen. This fact was obvious. Moreover, Barrich called Williams shortly before the May 20 article was published, and in that telephone conversation, Williams informed Barrich that the documents had been stolen. The intelligence project, including Barrich and Potok and SPLC, thus violated the Alabama criminal statute prohibiting receipt of stolen property, i.e. Section 13A816 of the Alabama Criminal Code. And you know what they do in Alabama. They arrest you, I guess. The intelligence project and SPLC paid Dillaway for the stolen documents. On information and belief, the amount paid for the stolen documents substantially exceeded $5,000, probably a statutory minimum for making that a felony or an aggravated felony. The intelligence project and SPLC thus violated the Alabama criminal statute prohibiting commercial bribery of a fiduciary, i.e. Section 13A11120 of the Alabama Criminal Code. The intelligence project and SPLC required Dillaway to sign a confidentiality agreement. Hey, SPLC, the guy just violated a whole bunch of confidentiality agreements, pursuant to which he was required to keep secret his receipt of payments for the stolen documents. Ooh, that's not good. That's not, if that's true, that's really bad. Look, we're going to acknowledge the illegal activity. We're going to need you to go ahead and be quiet about that and sign this document. It can never be found through discovery. Sign this document stating that you won't talk about the illegal activity that we did for you and with you. All the illegal things that we did with you. All the dirty, dirty illegal things. The intelligence project and SPLC thus not only knowingly received stolen documents, but actively participated in and induced the theft by paying for them. In September 2015, an attorney retained by Williams sent a letter to the SPLC in which the attorney identified the documents Dillaway had taken as stolen and requested their return. The intelligence project and the SPLC ignored this letter. Don't ignore the letter. You got a guy who he burned you. He burned the guys that you wanted him to burn. Why did you think he wouldn't burn you? The intelligence project and SPLC also ignored a subsequent letter to the same effect from the same attorney. On information and belief, the intelligence project and SPLC have paid not only Dillaway but other members, former members, friends, acquaintances, and spouses of former friends and spouses of members, and supporters of or former supporters of the National Alliance for information about the National Alliance. On information and belief, the Intelligence Project and SPLC have also paid members, former members, friends, acquaintances, and spouses or former friends, acquaintances, former friends. So they were former friends, now they're friends again. That's good. Acquaintances and spouses of members and supporters or former supporters of other hate groups as defined by the SPLC for information. On information and belief, at least some of the payments described in paragraph 68 and 769. I wonder if Gary Allen was like progressively drinking while typing this document, because the typos are getting worse. 68 and 69 are included in the compensation to disqualified persons set forth on the SPLC's Form 990s for 2015 and prior and subsequent years. Section D. The Intelligence Project's May 20, 2015 Chaos at the Compound article violates canons of legal ethics and is permeated with false statements. And if you have canons of legal ethics, you should put them on your legal ethics battleship and take to the high seas. Go after the Somali pirates with your cannons. In an article authored by Barrick and published in the SPLC's Intelligence Project Intelligence Report, of which Potok was the editor-in-chief, on May 20th, 2015, Barrick, fat lady, huge lady, presented a lurid, oh god, oh no, the account, whew. I thought she was posting lewds. Self-serving account of Dillaway's theft of the confidential National Alliance documents. The essence of Barrich's and the Intelligence Project's lengthy article was that Dillaway, an accountant, had allegedly documented evidence of embezzlement, money laundering, and tax fraud by the National Alliance, had presented this evidence to Will Williams, the chairman of the National Alliance, and to an attorney for the National Alliance, Tim Calamaros. That Williams and Calamaros had refused to rectify the alleged wrongdoing, that after Dillaway confronted Williams with evidence of the alleged tax wrongdoing, an altercation ensued on May 3rd, 2015, which caused Dillaway to run from the NA property, fearing for his life. That Dillaway, who had been, quote, active in the neo-Nazi white supremacist scene for more than a decade, notice who they turned to for all the help, right? Nonetheless took his alleged evidence of wrongdoing, i.e. the 6 thumb drives of documents he had stolen, to the SPLC, that even though Dillaway was subject to a confidentiality agreement and the documents included communications from Calamaros protected by attorney-client privilege, Dillaway, according to Barrich, was nonetheless free to disclose all the documents on the thumb drives, many of which had nothing to do with the alleged tax fraud, embezzlement, or money laundering, to the SPLC because Dillaway was supposedly seeking to prevent tax fraud, and that apparently on the same rationale, the SPLC was free to then disclose the documents to the world. Well, that's how you do it. If you want to prevent someone from committing tax fraud, you go straight to the SPLC. You got to go straight to the SPLC. That's how it goes. Landon Mackinjames says, "Get drinking, Nick. Gotta outperform last night." No, I gotta live through tomorrow, buddy. So tonight is not a drinking night. FluxCore. Yes, Lindsay Shepard sued by her inquisitors. I'll probably be covering that at some point. So of course, you know, they rebrand all of this, but it is funny, right? The SPLC hates all the hates the white nationalists, hates the racists. What do though? They dump a bunch of money into a neo-Nazi racist pockets as long as they can then use those illegal documents for their benefit. Okay. This narrative is permeated by false and misleading statements and important omissions, including the following. Does that mean the SPLC will now perform the thought audits? Yep. Let's hope so. As set forth in paragraph 58 of this complaint, there were 2 West Virginia deputy sheriffs and 1 park ranger present at the May 3rd, 2015 altercation. On information and belief, Dillaway did not mention to these law enforcement officers that he had in his pockets numerous thumb drives containing alleged evidence of NA tax fraud, embezzlement, and money laundering. Instead, he remained silent to the sheriffs and park ranger, but secretly took this supposed evidence directly to the non-governmental SPLC. This is not credible unless the Intelligence Project and SPLC encouraged the theft and paid Dillaway for it. I don't know if that's the only way it's not credible. He might have realized that he had stolen documents and didn't want to turn them over to the authorities while they were there. Further, even assuming arguendo that the evidence Dillaway allegedly uncovered might have legally excused his contacting an appropriate government officer despite Dillaway's confidentiality agreement, it did not excuse his disclosing the confidential documents to the SPLC, a non-governmental entity. Dillaway's disclosure to the Intelligence Project and SPLC was an unlawful breach of fiduciary duty, motivated by spite and greed, which the Intelligence Project and SPLC encouraged, aided, abetted, and exploited, and then bedded. That I added that last one. Moreover, even assuming, again contrary to fact, that Dillaway could have disclosed alleged evidence of alleged NA criminal wrongdoing to the Intelligence Project and SPLC without breaching his confidentiality agreement. Dillaway disclosed to the Intelligence Project and SPLC, and Intelligence Project and SPLC, for their own purposes of fundraising and destroying their political enemies, disclosed to the world information far beyond evidence of alleged criminal wrongdoing, e.g. the identities of persons who purchased controversial books. It's always the books. And the books they purchased, and accordingly the disclosures were nonetheless a breach of the agreement. See. Is there an update that I missed about Zach v. Meyer case? If you could, it's not fine. Yeah. Meyer versus Wade. Meyer versus Wade is in a holding pattern. They're in discovery, jurisdictional discovery right now. Probably not going to be much on that until next month, but there just haven't been any new documents for a while. Further, the SPLC, as a purported 501c3 public interest law firm, and its employees, including Barrich and Potok, are subject to canons of legal ethics with regard to their obligations on receiving confidential documents and communications protected by attorney-client privilege. Alabama rules of professional conduct to which the SPLC, Barrich, and Potok are subject provide as follows. Rule 4.4, transactions with persons other than clients. In representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate the legal rights of such a person. Maybe the problem with this claim is that the SPLC doesn't represent anybody, right? Like, that's the problem. A lawyer who receives a document that on its face appears to be subject to the attorney-client privilege or otherwise confidential, and who knows or reasonably should know that the document was inadvertently sent, should promptly notify the sender and abide by the reasonable instructions of the sender regarding the disposition of the document, or 2, submit the issue to an appropriate tribunal for a determination of the disposition of the document. Professional Rules 1.5, safekeeping property. Upon receiving funds or other property in which a client or third person has an interest from a source other than the client or the third person, a lawyer shall promptly notify the client or third person, except as stated in this rule or otherwise permitted by law or by agreement with the client. A lawyer shall promptly deliver to the client or third person any funds or other property that the client or third person is entitled to receive, and upon request by the client or third person shall promptly render a full accounting regarding that property. So that one definitely does apply. That one definitely does apply. The rules of professional conduct of other states and federal courts are substantially identical. Barrich, Potok, and the SPLC accordingly were ethically bound to return Dillaway's stolen documents to the NA and Calameros, or at a minimum, inform Calameros and the NA of the SPLC's receipt of the confidential and privileged documents, and either abide by their reasonable instructions or submit the issue to an appropriate tribunal. They did none of these things. Barrich, the Intelligence Project, and the SPLC had no right or authority ex parte, unilaterally, and without notice to deem the confidential documents no longer confidential and the privileged documents no longer privileged, and to then use them for their own purposes. Barrich's, the Intelligence Project's, and the SPLC's purported rationale for revealing the confidential and privileged information was in reality a pretext for their true self-serving aims, i.e. lucrative fundraising and attempting to destroy the NA and anyone connected with it. I've never even heard of the National Alliance. Just to put that out there. Are they big? Does anybody care? On information and belief, an important fact supporting this conclusion is that even though the FBI and IRS were informed of Dillaway's allegations regarding the NA's supposed tax fraud, embezzlement, and money laundering, no charges for any of these alleged crimes or any other have ever been filed. To the contrary, on information and belief, the deficiencies in the NA's tax records and reporting, which Mr. Williams has acknowledged existed as a result of the turmoil and disarray at the NA following William Pierce's death in 2002, were worked out with the IRS without so much as a civil levy and a foratory no tax fraud claims. Hmm. The May 20th, 2015 Chaos at the Compound article supports an inference that the SPLC negligently trained and supervised Berich and Potok. More specifically, the following facts and legal principles support this inference. Berich, the chief of the SPLC's intelligence project, was the author of the Chaos at the Compound article, including the parts of the article that evaluate legal questions such as whether Dillaway and the SPLC, including the intelligence project, could ethically disclose to the world and were legally excused from liability for Dillaway's breach of the confidentiality agreement for the SPLC's and intelligence project's disclosure of confidential and privileged communications. All right, guys, let me talk about that real quick. It is not illegal for... It is not illegal to distribute illegal documents or illegally acquired documents as a media piece. Does that make sense? So if there's an illegal recording that someone legally delivers to you with that you don't acquire illegally, okay? So if someone were to do something illegal and then anonymously send me the illegal gains for disclosure, and I have no idea that they're illegally obtained, then I could disclose them and be immune from liability for that. That's been a long-standing thing, especially in regards to media. Of course, this is not legal advice. Check with an attorney if you have a specific instance, blah, 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 blah. But when you participate in the illegality, or you know of the illegal acquisition of them, and you assist that through a payment, and then you admit to it by having the person sign a confidential document about the payment, then that becomes illegal at that point. Can't do that. You can't induce the illegal activity. You can't be a part of the illegal activity. But this covers, news outlets. When someone illegally records a video that would be of public interest, for example, at like a secret meeting, and then they just mail a copy of the tape to a news outlet, and then the news outlet gets this thing, is like, oh my gosh, this thing is crazy. They have no idea how that tape came to be, or whether it was illegally done or done with consent, and they don't need to. They can just go ahead and air that if it's newsworthy and they want to, and have some shelter from liability for that. So if this happened as they say, then the SPLC violated that. Now, there's extra stuff here because they're not only bound by law, but legal ethics, as mentioned above. And there are rules about how attorneys have to handle documents that are obviously protected by attorney-client privilege. Now I feel like Nick has secrets. Well, of course I have secrets. I'm an attorney. I have secrets that I'll have to take to my grave. Let's see. 2, for the reasons previously stated, the rationale presented in the article to purportedly justify Dillaway's and the SPLC's breaches and disclosures was egregiously wrong, and of equal importance, Berich should not have made or been involved in making this decision. On information and belief, Potok, as editor-in-chief of the Intelligence Project's publications and one of its primary researchers, worked with Berich on the Chaos at the Compound article, and the SPLC, a purported 501c3 public interest law firm, is obligated to train not only its lawyers, but its non-lawyer employees, such as Fatso and Ugly, to comply with professional and ethical standards governing lawyers and law firms. Go. SPLC's August 17th article. So this is the one that focuses on Allen specifically. On or about August 17, 2016, Berich, the Intelligence Project, and the SPLC widely published an article that caused Allen to lose his position as an attorney at the Baltimore City Law Department, destroyed his future prospects of employment as an attorney, and ravaged his hard-earned reputation. So there's, man, everybody's getting Me Too'd as a competent and ethical attorney. Berich and the SPLC intended all these consequences. Indeed, they carefully orchestrated them. The following are salient points regarding the August 17th article. Giuseppe Balsamo. If any of this is true, why can't the lawyers at the SPLC be disbarred for violating ethical standards? they could be disbarred, but the they could be disbarred, but that's probably not the punishment they would get. They would probably just get they'd probably get some sort of disciplinary action, but disbarment takes a lot. I mean, they might. I guess they could. They really did hose this one guy over and cause him pretty much irreparable damage. But it's weird to see attorneys get disbarred unless they really screw over their own clients. Okay, Beerich, the Intelligence Project, and the SPLC used confidential Dillaway stolen documents in the article. The article incorporates photographs of and discusses the following from among the Dillaway stolen documents, all manifestly confidential. Let's see. Oh, is the stream not running nice on StreamMe? It's running nice for me on my window of StreamMe, but I apologize if it's not running nice for you. On my end, it looks pretty good. So I don't know what to tell you. Sorry. The man is dancing naked on your lawn while glaring at you creepily. Can you shoot him? Depends on the state. Depends on the state. Okay. The article incorporates, from among the Dillaway stolen documents, all manifestly confidential. First, a letter dated February 14th, 1987 from William Pierce to his attorney Gerald Dmitrovic, Esquire, in which Pierce sought legal advice regarding the actions of the local West Virginia sheriff, Jerry Dale, in inter alia, flying over Pierce's property, taking photographs, and providing the photographs to local media. The letter mentioned and CC'd Allen. This stolen letter, improperly disclosed by Beerich and SPLC to the public to suit Beerich's and the SPLC's aim to destroy Allen, was, to quote Alabama Rule of Professional Conduct 4.4, a document that on its face appears to be subject to the attorney-client privilege or otherwise confidential. Beerich's and the SPLC's use and public disclosure of this document thus violated Rule 4.4, as had their previous use and disclosure of the Calamaros confidential and privileged documents in Beerich's and the SPLC's May 20, 2015 Chaos at the Compound article. Next, a receipt for a subscription to NVM and a dues payment dated November 22nd, 2002. Next, a receipt for a dues payment and a donation to the National Alliance dated May 6, 2003. A receipt for a Jailing Opinions DVD dated July 11, 2007. A receipt for attendance at a Holocaust Revisionist Conference dated October 1st, 2007. Wow. That one doesn't look good for an attorney. Unless you have a good answer for why you attended it. Beerich's, the Intelligence Project's, and the SPLC's aims by means of the article successfully achieved were to destroy Allen's vocation and reputation, make a public example of him, and arrogate to themselves veto power in employee hiring. Although the premise for the SPLC's immensely lucrative tax-exempt 501c3 status is that it is a public service law firm dedicated to an educational mission. Ooh, maybe I should do that. Maybe I'll go tax-exempt and dedicate my law firm to an educational mission, right? Talking about dummies on the internet. Its predominant aims, as previously explained, are to destroy organizations and individuals of whom it disapproves ideologically, and to limit public discussion of controversial issues such as race, sexual orientation, and immigration. Consistent with these overarching goals, Beerich's, the Intelligence Project's, and the SPLC's objective by means of the August 17th article was to destroy Allen's vocation and reputation, to deter others from straying off the reservation, so to speak, i.e. from stepping outside the narrow ideological confines the SPLC presumes to define and permit by shaming Allen in public, and to achieve veto authority over the hiring decisions of entities such as Baltimore City, or indeed any employer. Several aspects of the article, August 17 article described below, make these destructive aims manifest. Yeah, actually, as I'm thinking about that, making Rekieta Law a 501c3 tax-exempt organization for the purposes of educating the public about legal issues is a great idea. That's fantastic. Northern Prosperity Law Center, do it. I could be a legit 501c3 First Amendment advocate. This is good. This is good. Birich, the Intelligence Project, and the SPLC carefully orchestrated a media frenzy about Allen's employment by the city of Baltimore. Within 2 days of the publication of the article, Allen and his wife were deluged. That is a soaked with a downpour, with telephone calls at his home from media as far away as California and England. Not to mention New York, Washington, D.C., and Baltimore. And found Fox television news reporters outside their house. No one wants that. No one wants that. This frenzy did not happen fortuitously. It was planned and fomented by Birich, the Intelligence Project, and the SPLC by sending press releases about the article to their media friends and contacts all around America and in other countries. As Laird Wilcox has observed, anyone attacked by the SPLC is basically up against a contest of resources, from the ability to engage legal counsel, to access to fairness in media treatment, to the ability to survive the financial destruction of a reputation and career. Oh, you know what's interesting? I just noticed when you retract a message on the YouTube chat, it doesn't retract it from the restream chat, so I can see what you said. See. Yeah. Anyone attacked by the SPLC is basically up against a contest of resources. From the ability to engage legal counsel, to access to fairness in media treatment, to the ability to survive the financial destruction of a reputation and career. What they do is a kind of bullying and stalking. They pick people who are vulnerable in terms of public opinion and simply destroy them. Their victims are up against a very talented and articulate defamation machine. Birich's The Intelligence Project, and the SPLC's rationale for the August 17 article, to the degree any coherent rationale can even be discerned, is manifestly pretextual. The article's apparent rationale is that Birich, the Intelligence Project, and the SPLC, in their wisdom, felt themselves duty-bound in the supposed best interests of the city of Baltimore to publicly berate the city and disrupt its operations because the city supposedly had hired a, quote, well-known neo-Nazi lawyer to work on its cases, particularly the Burgess case. But the article harmed, not benefited the city. The city lost an experienced attorney, Allen, who was, one, doing competent work, e.g. the only pleading he worked on in the Burgess case was a motion to bifurcate, which the court granted, thereby significantly benefiting the city's legal position, and two, working harmoniously with his fellow city employees. Moreover, as a foreseeable consequence of the article, the city also lost the services of George Nilsson, the city solicitor, one of the finest and most effective civil servants ever to occupy that office. The SPLC and Fat Lady, in contrast to the city, which later suffered a $15 million verdict against it in the Burgess case, profited handsomely from the article. They stayed in the news as supposed experts on extremists, which kept donations flowing to the SPLC's already massive bank accounts. They destroyed Allen, who the SPLC assumed had views of which it disapproved, and they destroyed Allen in public, thus creating an in terrorem effect, dissuading others from adopting or at least avowing views on controversial issues such as race that departed from the SPLC's approved views. The support Birich, the Intelligence Project, and the SPLC offer in the article for the assertion that Allen is a well-known neo-Nazi lawyer is farcical. Apart from the article's fraudulent characterization of the American Eagle Party addressed below, the article states, quote, there is more publicly available information on Allen's association with extremists. Allen was publicly identified as the attorney for the National Alliance on the neo-Nazi Vanguard News Network forum almost a decade ago. In a post by current NA chairman Will Williams, the SPLC also reported Allen as the NA's attorney in an article last year. The article's first purported support link is a link to a VNN forum. On information and belief, Allen was unaware even of the existence of the VNN forum until he saw it mentioned in the SPLC article. The forum posts hundreds of rambling, gossipy, often incoherent posts a week. Almost always from anonymous participants with some kind of personal axe to grind. To assert, as the article has, that one obscure reference to attorney Glenn Allen, buried in one post on a gossipy forum that gets hundreds of posts a month, shows that Allen is a well-known neo-Nazi lawyer, illustrates the depths to which Barich, the Intelligence Project, and the SPLC stooped to advance their aim of destroying Allen. Now, to Barich's defense here, she doesn't have to stoop too far because gravity is working really hard on all that skin. Barich's, the Intelligence Project, and the SPLC's destructive aims are similarly transparent in the August 17 articles reference to the SPLC and Intelligence Project's own prior May 2015 Chaos at the Compound article. Now, the interesting question is, was he the attorney for the National Alliance? Was it true? Was it true? There is something circular and manipulative in the SPLC and Intelligence Project citing their own prior article for the proposition that Allen is a well-known neo-Nazi lawyer. In any event, now notice well-known and neo-Nazi are in separate quotes. This is a nice rhetorical trick because in the sentence it paints him as a well-known neo-Nazi lawyer, but it should be a well-known, comma, neo-Nazi lawyer. They're two separate descriptions of him. He's a well-known lawyer and a neo-Nazi lawyer, according to them. So this is a little disingenuous how he's written that, because they're not saying he's a well-known neo-Nazi, right? They're saying he's a well-known lawyer and a neo-Nazi lawyer. In any event, I'm not defending the SPLC by any means, but let's just be honest about what's happening. In any event, the lengthy, over 10 pages, May 20, 2015 article that the SPLC and Intelligence Project cite in the August 17 article refers to Allen only once as follows. According to a December 2007 post on VNN, Williams ultimately blamed longtime National Alliance lawyer Glenn Allen for siding with Glebe at the time. May 20 article thus merely cites to the VNN post, which, as mentioned, is a single phrase buried in a single post on a gossipy forum that gets hundreds of posts a month. Further, after the August 17 article, the SPLC and Intelligence Project directly contradicted their early pretextual, quote, "How dare the city of Baltimore hire a well-known neo-Nazi lawyer" rationale. In its 2016 hate map, published in 2017, the SPLC and Intelligence Project featured a photograph of Allen, stating under the photograph, inter alia, hate group members and followers of their ideology sometimes manage to obtain important positions of power. When the city of Baltimore recently hired Glenn Keith Allen, a neo-Nazi, nobody knew of his involvement with white supremacist groups except for us. Because of our investigation and expose, he was swiftly fired. Jiro1 says, Mike is muted. Don't lie to me, boy. Don't lie to me, boy. On information and belief, the SPLC has published similar statements about Allen before and after the publication of its 2016 hate map in 2017. Thus, when the SPLC's and Intelligence Project's predominant purpose was to embarrass the city of Baltimore so it would fire Allen and institute new hiring practices under which persons seeking employment must be subjected to political tests overseen by the SPLC and Intelligence Project themselves, they characterize Allen as a well-known neo-Nazi lawyer. When, however, it later suits their fundraising purposes to boast about their massive surveillance capabilities, they proclaim that nobody knew of his involvement with white supremacist groups, except for us. The Intelligence Project and the SPLC feel themselves so powerful in wealth, reputation, and bullying power that their actions are beyond challenge. They need not hesitate to make contradictory and untruthful statements at their whim if doing so suits their purposes. Basically, they're on YouTube, right? Finally, the Intelligence Project and SPLC interchangeably describe Allen as an attorney for the National Alliance and as a neo-Nazi lawyer, a smearing technique that ignores the admonition of legal ethics that lawyers should represent a fair share of unpopular matters or unpopular clients, especially if no other attorneys will do so. And this, of course, is the nefarious part of it. Even if he were the lawyer for Hitler, Hitler still gets a lawyer. Everybody still gets a lawyer. Child rapists still get a lawyer. Hillary Clinton will still get a lawyer. The guy keeping Ginsburg alive still gets a lawyer. Everybody gets one. And it doesn't mean anything about the lawyer. Like, that's just how it goes. The Intelligence Project and SPLC sought and achieved unconstitutional results by means of the article. The Intelligence Project and SPLC carefully targeted Allen for destruction. Birich, head of the intelligence unit at the SPLC, said they've watched Allen like a hawk. They did so not because he was disruptive at his place of employment for the city. He was not. Not because he was incompetent as an attorney. Even Birich acknowledged in her August 17th article that Allen may well be a skillful attorney, but because he had, in Birich's view, the worst ideas ever created. This East Europe communist thought crime surveillance mentality is antithetical to fundamental American cultural and constitutional principles protecting freedom of expression and association. From Madison and Jefferson in the early days of the Republic, quote, I flatter myself I have in this country extinguished forever the ambitious hope of making laws for the human mind. Andrew Gluck says Saddam Hussein gets a lawyer. Well, didn't help much, did it? Through Justices Holmes and Brandeis's dissents in Abrams versus United States, to the Supreme Court's decisions in Brandenburg versus Ohio, and more recently in Phelps versus Snyder, avatars of the American cultural experiment in free expression have condemned and guarded against criminalization of mere thought, such as the SPLC effectively enforces. Government employees, such as Allen, governmental employees such as Allen do not forfeit these constitutionally protected free speech rights by virtue of accepting government employment. See Rankin versus McPherson. Heffernan versus City of Paterson, New Jersey. Moreover, a governmental entity may not retaliate against an independent contractor or a regular provider of services for the exercise of freedom of speech. And that's quoting O'Hare Truck Service versus City of Northlake. The Intelligence Project and SPLC employed false statements and implications in the August 17th article. SPLC is Southern Poverty Law Center, Shane Zelinsky. They are a terroristic hate group that hates gays and is a bunch of racists. Prominent among the false statements and implications in the August 17 article were those concerning the American Eagle Party. The article's assertion that the AEP is racist is false. As noted previously, there were no racial elements in the AEP's platform or membership criteria. During its brief existence, it was open to persons of all races, religions, and sexual orientation. In fact, Merlin Miller, the West Point graduate and film director who founded the AEP, resigned from a prior party because of that party's racial elements. Miller had previously produced and directed the film Jericho, which features an African American in a major and positive role and has an anti-discrimination theme. Part of the AEP's aims was to widen the national debate to make it more inclusive and more civil on controversial topics. To that end, Allen and Miller explored the concept of an AEP affiliate that would present a forum for open but civil discussion on controversial issues with an aim to present both sides of the debate. In this spirit, unrehearsed and half in jest, Allen went through a rough experimental first take on broadening that debate on vaccination. The implication in the August 17th article that Allen or Miller posted this rough, unrehearsed first take on Stormfront is false. Neither Allen nor Miller did so, and neither even knows how the rough first take came to be posted there. In any... The Nazis are strong. They have resources far more vast than the SPLC. In any event, advocating widening debate on vaccination, or indeed any topic, is not hate, wherever it is presented, even though Birich attempts to portray it in this manner. Inclusion of the vaccination rough take in the August 17th article in reality accomplished several goals for the Intelligence Project and SPLC. One, it made Allen look ridiculous. Two, it linked him to Stormfront, linked is in quotes. And three, it sent the message to Allen and the others, we are watching everything you do all the time. Started playing that every move you make song. Would the SPLC wouldn't use Sting's version, would it? They'd use P. Diddy's, right? They'd have to. They'd have to. The August 17th article's lengthy discussion of the Burgess litigation and obvious sympathy for Burgess implies that Allen had acted or would act unethically and improperly with regard to that litigation. Allen, however, did nothing other than represent his client, the city of Baltimore, zealously and competently and in full compliance with his ethical obligations with regard to the Burgess case and all other cases on which he worked. The article's implication to the contrary is false. Now, the shame of this man is not that he's a racist, it's that he's a statist bootlick. That's his problem. Birich, the Intelligence Project, and SPLC deliberately omitted highly relevant facts about Allen from the August 17th article that would have contributed to a less one-sided and demonizing portrait of Allen. Laird Wilcox, a critic of the ritual defamation practiced by the SPLC and others, has observed, in order for ritual defamation to be effective, the victim must be dehumanized to the extent that he becomes identical with the offending attitude, opinion, or belief, and in a manner which distorts it to the point where it appears at its most extreme. The power of ritual defamation lies entirely in its capacity to intimidate and terrorize. It embraces some elements of primitive superstitious belief, as in a curse or hex. It is important to recognize and identify the patterns of a ritual defamation. Like all propaganda and disinformation campaigns, it is accomplished primarily through the manipulation of words and symbols. It is not used to persuade, but to punish. Although it may have cognitive elements, its thrust is primarily emotional. Ritual defamation is used to hurt, to intimidate, to destroy, and to persecute, and to avoid the dialogue, debate, and discussion upon which a free society depends. On those grounds, it must be opposed, no matter who tries to justify its use. Birich's The Intelligence Project and SPLC's August 17 article, in accord with the blueprints Wilcox describes, achieved its goal of dehumanizing Allen by omitting any facts suggesting that Allen, although a fallible human being who has made mistakes, has redeemable qualities. It may be objected that the SPLC, including the Intelligence Project, has no obligation to prevent even the semblance of balance in its articles. Like a supermarket tabloid such as the National Enquirer, this objection might contend the SPLC is free to present as one-sided, exaggerated, sensationalistic a description as it chooses. Such an objection, however, overlooks the fact that the SPLC is not a for-profit newspaper such as the National Enquirer. It is a 501c3 nonprofit that has received favored and lucrative tax-exempt status based on the premise it is a public service law firm with an educational mission. Concept of education and the privilege of tax exemption impose some degree of obligation for fair balance in its articles. See 26 CFR section blah blah blah. 501c3. An organization may be educational even though it advocates a particular position or viewpoint, as long as it presents a sufficiently full and fair exposition of the pertinent facts as to permit an individual or the public to form an independent opinion or conclusion. I'm not going to read that next citation. It's long. Among the destructive, one-sided, distorting aspects of the August 17 article are the following. Before that, Jira says, how much of this is legal argument and how much is just grandstanding for the court of public opinion? I have 150 characters left, so F the SPLC, subscribe to PewDiePie, Fat Loads, and Battletoads. There you go, buddy. There you go. They're making a very difficult legal argument. Moment of reality. Real talk. Even though the man in the dress who punched Jeremy Hambley doesn't think real talk means real talk. Real talk. This is an uphill battle that Glenn Allen is facing. Gary Allen? Glenn Allen? I don't even remember his name. Allen, the white nationalist attorney, is facing. Very difficult case. He's bringing up claims that are pretty tough. He's trying to show that they have false statements. He's trying to show that they acquired documents illegally. It's tough. It's a tough case. So laying all this out, he's being very thorough and methodical, but it is very wordy. But it is all directly related to the legal argument. I don't think he's trying to win the court of public opinion, but he is, a little bit, right? Of course. But he has to counter the narrative. He has to show over and over as much as possible that the mischaracterization of him will lend to the idea that not only did they mischaracterize him, but they actually made false statements. That's the trick. Like they can mischaracterize him all day, and they can make true or false statements all day. What he's trying to do is link the mischaracterization, the gross mischaracterization, the overt mischaracterization into the false statements. Because if he can do that and convince the judge that these are false, not just opinions, but they're actually doing false statements because of their opinions, then he could win on the defamation claims. All right, the article omits any reference to the abundant pro bono work Allen has done for African Americans and others, as detailed in paragraphs 47 and 48. Barrick, the Intelligence Project, and SPLC can hardly claim they were unaware of Allen's pro bono work. Barrick has posted publicly that she was watching him like a hawk. Fatso, the Intelligence Project, and SPLC conducted surveillance on every aspect of the American Eagle Party, a minuscule political party that existed only a short time. Barrick, the Intelligence Project, and SPLC found one allusion to Allen buried in one post on information belief, hundreds of posts a week on a forum called the VNN Forum. Evidence that Barrick and the Intelligence Project and SPLC have dedicated enormous manpower and resources to reading and keeping databases from dozens of chat rooms and forums. In Barrick, the Intelligence Project and SPLC combed through pleadings to find Allen mentioned as one of nearly a dozen attorneys involved in the Burgess litigation. Given Barrick's, the Intelligence Project's, and the SPLC's gigantic budget, their public statements, and their manifestly large and aggressive surveillance operations, it is hardly credible that they were unaware of his pro bono work in the Unger Wayne matter, a headline-making case in which Allen's name appeared on an important amicus brief filed in the Maryland Court of Appeals, or the Stowers-Lloyd matter, in which the federal court commended Allen in a memorandum opinion. Moreover, they could easily have learned of Allen's other pro bono activities, such as mentoring DeAndre Johnson for 4 years, from a single call to his former law firm. Barrick, the Intelligence Project, and SPLC, however, were uninterested in any aspects of Allen's life except those they could use to destroy his vocation and reputation and make a public in terrorem example of him. Dun, dun, dun. Dun, dun, dun. The article discusses Merlin Miller's statements at a press conference in Iran regarding a possible Mossad role in the 9/11 attacks, but omits the larger purpose of Miller's visit to Iran. To open channels of communication and friendship with an Islamic country for the context of escalating calls for military conflict between Iran and the United States. The article falsely portrays Miller as a hater, when in fact he was a peacemaker. He's a lover, not a hater. Lover, not a hater. Okay. Harms to Allen from the August 17th article. All right. We're on paragraph 95. Bottom of page 48 for those following along by audio. The damages caused to Allen by the article were immediate, devastating, and long-lasting. The article caused Allen's immediate termination from his employment at the City of Baltimore's Law Department. Barrick, the Intelligence Project, and SPLC have publicly boasted that Allen's termination was a result they caused and intended to cause by the article. At the date of his termination, Allen was an independent contractor attorney for the city, earning approximately $90,000 a year. He was performing his job duties competently and working harmoniously with his coworkers and supervisors. He had excellent prospects for securing a permanent position at the city law department within a year at a salary of $105,000 or more. Allen was in good health, physically and mentally. He had recently set the Maryland State Senior Olympic record for the 400-meter dash for his age group and was ranked 4th in the world for the pentathlon for his age group. He planned to work another 10 years for the city and would have done so but for the article. The article gravely damaged Allen in his vocation as an attorney specializing in trial and appellate litigation. Not only was he permanently branded as a neo-Nazi lawyer based on the Dillaway stolen documents, but any attempt by him to gain employment from any governmental or private entity became subject to Barrick's, the Intelligence Project's, and SPLC's repetition of its ritual public shaming. Allen, at Barrick's, the Intelligence Project's, and SPLC's caprice, would be subjected again to a similar devastating public attack. Allen could not, in good faith, fail to inform potential clients or employers of the article and the threat of a new and similar article which enormously complicates Allen's attempt to create a good working relationship with his clients or employers and gain their trust. I talked about this in one of the defamation videos, that you can force someone to make defamatory statements about themselves, basically, if you make the statements to the person and or in this case in a publication, and you make the statements knowing that they'll be forced, due to the nature of the statements, to disclose them to future privileged communications, like a job interview, right? If he goes to a job interview, it's gonna say, hey, by the way, just so you know, if you hire me, you're gonna get hounded by a bunch of chumps at the SPLC. I know if you just throw cakes out, the one lady will probably just scarf them up and get distracted, but it's gonna happen. I'm sorry. Here's why. They think I'm a Nazi. It's just that. It's just that. So if you hire me, you're going to get articles about you, calling you someone who hires a Nazi, but I respectfully submit my resume, right? Like that's what he has to deal with. The widespread, sensationalistic, and unending publicity from the article, which remains on the SPLC's and Intelligence Project's website, carries with it the potential to taint Allen's effectiveness before judges and jurors, who may feel animosity towards him, even if not acknowledged, based on SPLC's and Intelligence Project's characterization, and let this anger affect their treatment of his clients. The article's horrific impact on Allen's reputation is exemplified by his former law firm's immediate withdrawal of the glowing testimonials that members of the firm had previously provided for Allen and he had posted on his website, as described in paragraph 50 of this complaint. Within a day of the publication of the article, the firm called Allen to request that the testimonials be removed from the website, which Allen did. Ouch. 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 The SPLC's and Intelligence Project's hate maps and list of hate groups, anti-LGBT extremists, and anti-Muslim extremists are permeated with fraud. As we all know this. The SPLC and the Intelligence Project have published hate maps and lists of hate groups for several decades, and lists of anti-LGBT extremists and anti-Muslim extremists on information and belief for several years. Numerous observers and victims of these publications have presented well-grounded factual predicates adopted in this complaint for concluding that the publication contained deliberately misleading or inaccurate statements. The SPLC and Intelligence Project intentionally inflate hate group tallies. Yes, this is of course, this is the fundraising technique, right? Magnify the problem to amplify the amount of money you get for the solution. That's how you do it. That's how you do it. Yes, yeah. The SPLC's and Intelligence Project's calculations of the number of active hate groups in the U.S. on its annual hate maps, including the hate map it mailed around the U.S. in 2017, have been repeatedly false and fraudulent. Many critics have criticized these numbers as intentionally inflated. C.E.G. Harry Zeev Cohen, an anti-hate group that jumped the shark, the Hudson Institute. This year, the SPLC identified a threefold increase in anti-Muslim hate groups by changing its accounting rules. Act for America, a 500,000-strong legislative advocacy group organization whose classification as a hate group was already questionable, was suddenly counted 45 times, one each for 45 of its 1,000 local chapters. Such shoddy work makes it no wonder that FBI hate crime investigators officially stopped relying on the SPLC analysis in 2014. J.M. Berger, the hate list. Reasonable people can debate the reasons for including or disqualifying each of these listings, but the number of entries that require such debate is staggering, given the specificity of the SPLC's reporting. We're not talking about a difference of 5 or 10% in the relative counts. It's 65 or 70%. Richard Keefe, Watching the Watchdogs. Was cited like several times. Good job. A specific instance of the SPLC and the Intelligence Project fraudulently cooking the books in their hate group tallies is their is their designation of 40 hate groups in New Jersey in their 2014 hate map. A New Jersey newspaper reporter investigating the claim contacted Mark Pitkavaj, director of research at the Anti-Defamation League, who stated, as paraphrased in the newspaper article, SPLC has a habit of counting single individuals as groups or chapters, which can give a skewed impression of hate groups in any given state. And further, the Southern Poverty Law Center's list is wildly inflated. They list skinhead groups in places where there are no organized groups, but instead it's just a couple of individuals. That's from Jason Leday, the South Jersey News. SPLC uses an amorphous, self-serving definition of hate group at odds with its widely accepted connotation. The usual widely accepted connotation of hate group, especially an active hate group, includes a primary purpose of inciting or promoting hostility against another group. The FBI definition of hate group reflects this common understanding. Quote, hate group, an organization whose primary purpose is to promote animosity, hostility, and malice against persons of or with a race, religion, disability, sexual orientation, ethnicity, gender, or gender identity which differs from that of the members of the organization, e.g. the Ku Klux Klan, American Nazi Party. See Criminal Justice Information Services Division Uniform Crime Reporting Program, Hate Crime Data Collection Guidelines and Training Manual. Whew. Moreover, given that hate groups are closely associated in the common understanding with hate crimes, connotation of hate group includes a proclivity for, if not active participation in, violence and intimidation. See the FBI's definition of hate crime. Quote, a hate crime is a traditional offense like murder, arson, or vandalism with an added element of bias. All right. The SPLC. Wait, where did it go? The SPLC itself emphasizes this link between hate groups and violence. In bold letters at the top of the 2016 hate map, it states, hate and anti-government extremist groups continue to operate at alarming levels in the U.S., fomenting racist violence, seeking to poison our democracy, and in some instances plotting domestic terrorist attacks. It is accordingly false and outrageous for the SPLC to smear as hate groups conservative Christian groups that on no fair and objective interpretation could properly be so stigmatized. SPLC will assert that it's free to define hate groups as it wishes to advance its own agenda. There are at least two flagrant flaws in such an assertion. First, allowing the SPLC to define hate groups to suit its own purposes ignores the reality that the usual connotation of hate group continues to resonate at a deep emotional level with the general public and consequently continues to inflict grave harm on organizations branded with this label. From the Washington Times, being classified as a hate group by the SPLC has been costly for the Ruth Institute, a Catholic nonprofit dedicated to combating the breakdown of the family. First, the online retail giant Amazon refused to allow the group to be included on its Amazon Smile charitable giving program. Then last week, Vanco Payment Solutions dropped the ministry from its online donating processing service. There you go. There you go, right? This has been going on for a while. The deplatforming and the demonetizing just take away their ability to get money from people who want to give them money. Second, the SPLC's definition, which speaks of groups that attack a selective list of other groups, is cunningly equivocal. Given this equivocal attack language, and one, the SPLC's practice of explicitly accusing the hate groups it identifies of fomenting racial violence, and two, the SPLC's prominent inclusion of the KKK on its hate group list, the SPLC's purported redefinition is shown to be a transparent ploy to give the SPLC cover to destroy nonviolent groups who fail to adhere to their political agenda. The inclusion of the Ruth Institute, a conservative Catholic organization, on the list of hate groups on the SPLC's 2017 hate map published across the United States and sent to organizations such as GuideStar USA and Amazon Smile Foundation Incorporated is representative of the fraud that permeates the SPLC's hate map and hate group lists. Although the Ruth Institute has made statements critical of homosexuality, it is a Christian organization for which hatred is antithetical to its Christian values. Jennifer Roback Morse, president of the Ruth Institute, has made clear that it has never practiced, threatened, or condoned violence or intimidation against other groups. We don't incite anybody to violence. We don't say we hate anybody. We don't demean anybody, said Ms. Morse. We disagree with certain policy positions that are being aggressively promoted by professional gay rights organizations, but we disagree with their policies. That's all. I think you might disagree with more than their policy. If we're being honest. But doesn't mean you hate them. This means you might disagree with where they put their pee-pee. That rhymed. That was nice. That was nice. The Intelligence Project and SPLC published false statements regarding Maajid Nawaz. Maajid Nawaz is British of Pakistani origin. Oh, hey, someone earlier mentioned Maajid Nawaz. He's the author of Radical, a book published in 2013 which recounts his journey into and out of Islamic extremism. Although Quilliam, an organization he created, and in other ways he has worked to counter through Quilliam, an organization he created, and in other ways he has worked to counter extremism of all types, but particularly Islamist extremism, by encouraging civil discussion, education, and other nonviolent means. His activism has included such courageous actions as traveling to Pakistan to show open support for Malala Yousafzai. You know who I'm talking about, that chick. The young girl whom Taliban gunmen shot in the head and attempted to murder for her activism in promoting female education in Pakistan. I got a joke for that one, but I won't say it. Like, you can't even say it. You'll be labeled a hate group for making a joke, right? It was accordingly. Oh wait, it's probably safe because I'd be making a joke about the Muslims trying to quickly educate her by putting ideas straight into her head, right? And since the Muslims were doing it, that makes it okay to make a joke about it. Because it's only not okay to make a joke against the Muslims, I think, right? What are the rules? What are the rules on Muslim jokes? Does anybody know? Can someone call? Can I get Louis C.K. on the line and find out the proper rules for jokes of various demographics? It was accordingly astounding for Nawaz, who remains a reformist liberal Muslim, to discover himself on the SPLC's list of anti-Muslim extremists, a list prominently displayed on the SPLC's website in 2016 that was propagated all around the world, endangering his life. It is true, Nawaz has been critical of his own Muslim religion in many respects, but it is also true he has defended Islam as essentially a religion of peace. That's why they have trucks to deliver peace all over the world. For example, in debates against Ayan Hirsi Ali, a Somali-born former Muslim and activist who survived female genital mutilation and a forced marriage, but who has also been listed by the SPLC as an anti-Muslim extremist. Well, of course, she's opposed to female genital mutilation. She hates Muslims. In any event, it was presumptuous in the extreme for the SPLC to smear Nawaz as an anti-Muslim extremist and implicitly link him to hate speech for his nonviolent criticisms and attempts to liberalize and reform his own religion. Quote, after leaving my Islamist group, I decided many young Muslim minds desperately needed help in moving away from totalitarian worldviews and towards more constructive and inclusive dialogue. Quilliam was founded to act as an intellectual hub and center of gravity for former Islamists like myself, to use as a platform to start encouraging a more critical and progressive attitude in the Muslim way of thinking, which had come to be dominated by Islamism. It's Islamism. Did Louis C.K. copy strike Sargon? No, that didn't happen, did it? Oh, man. That's terrible. Why did he do that? I saw Sargon at a video. I didn't watch it. Dang it. Now I got to look that up because that's pretty funny. He did it personally? As in so many other instances of... Oh my gosh. Oh my gosh. Poor Sargi can't even catch a break from Louis C.K. Wasn't he defending Louis C.K. in that video? I didn't watch it. I saw it and I was like, I got my kids around right now. I can't watch this. I'll watch it later. But it looked like a video defending Louis C.K.'s racist rant or whatever he just did. Like his jokes that he made. But I don't know. Maybe he wasn't. I didn't. If anybody saw it, I want to know. As in so many other instances. No. Siren Jag says this guy is complaining because Muslim thinking is dominated by Islam. No, by Islamism. Islamist thinking is different than Muslim thinking. Islamists are like, it'd be like a Zionist, right? Like Judaism, Zionism is to Judaism as Islamism is to Islam, if that makes any sense. But it's about Islamist thinking, if I understand correctly, is about promoting Muslim supremacy rather than espousing the peaceful tenets of Islam. So Islamists believe in delivery by truck. That's what we're getting at. As in many other instances of SPLC hate and extremist labeling, Birich was at the forefront of the attack on Nawaz. Well, she wasn't at the forefront. You just couldn't see anybody else behind her. Falsely claiming that he asserted that all Muslims were potential terrorists and that he advocates that all mosques be surveilled. The SPLCs also falsely stated that Nawaz advocates a blanket ban on wearing of Muslim veils or niqabs. Niqabs? The SPLC further included in supposed support of its smear of Nawaz the alleged fact that he attended a bachelor party at a nightclub. Watch out! Okay, so yeah, Sargon was defending Louis C.K. and Louis copyright struck it. That's great. Oh man. Even assuming this allegation to be true, such an assumed fact has no bearing on whether Nawaz could properly be characterized as an anti-Muslim extremist. There's another instance of the SPLC's method of destroying by personal attacks and tabloid scandal mongering those persons and organizations the SPLC has determined have crossed the lines of permissible speech it has drawn. Louis C.K.'s routine was genuinely funny. And yes, I'm really glad that he did make fun of David Hogg and the other chumps running around pretending to be experts on guns just because someone shot some of their friends. My sympathies that you had to go through a terroristic event. My sympathies that friends of yours have perished and that it's traumatic and horrible for you. Doesn't make you an expert on gun policy. Actually, every time you open your mouth, David Hogg, it shows you to be not an expert on gun policy. And I don't care how many organizations had to pay Harvard to take you in. You don't deserve to be at any university because you're dumber than most 18, 19, 17. How even old is this kid? Dumber than most of them. Okay. The SPLC's scurrilous thought control campaigns sometimes misfire. And its smear campaign against Nawaz did in this instance. Nawaz fought back, finding the SPLC's characterization outrageous and several of its statements in purported support of the characterization false and disparaging. Nawaz announced his intention to sue the SPLC for defamation. The SPLC then, in the words of one commentator, caved spectacularly. Good. It admitted it had made errors, acknowledged it had not done adequate research, deleted its anti-Muslim extremist list, publicly apologized to Nawaz, and then paid him $3.3 million in settlement. This illustrates the SPLC's modus operandi. Smear recklessly, fundraise off the smear, then if forced to, but only if forced to, investigate the facts. So, the SPLC has to be raped into investigating the facts. I wonder if we could get Bill Cosby to quaalude them into investigating the facts. Like, put him to sleep and put subliminal... Yeah. If you send the SPLC to Cosby's house, he'll give him a drink laced with quaaludes, and then when they pass out, he'll put on a tape full of facts and some headphones on them, and they'll subliminally be forced to investigate. That's good. Good job. Good job, Cosby, doing the world a service. Excitable Boy says, Islamism is a word made up by moderates as if it's not what the Quran actively mandates as proper behavior. And as, you know, I'm willing to accept that but I don't know enough about the Quran to know, like, to make comments on it. What I've heard from other people about it, about how it's read and stuff like that, sure sounds like your assessment is correct. But who am I? Who am I? As long as they're not blowing people up or running them over, I don't care what people do, right? Like, I don't care who you worship. It just doesn't bother me. Just don't kill people. How's that? Well, and all the other oppressive stuff too, right? The SPLC's and Intelligence Project's February 2017 hate map falsely accuses Allen of infiltrating the Baltimore City Law Department. The SPLC hate map, published in 2017, all across the U.S., prominently displays Allen's photograph next to the caption in bold red, exposing racists who infiltrate public institutions. If you think that racists have to infiltrate public institutions, I've got the news for you. They don't have to infiltrate anything. Public institutions have no problem hiring racists and do so with regularity. Excitable Boy says, also, Lex Volt, Adeptus Arbeit stream win. Yeah, that'd be good. I do, I want to do some 40K stuff, and I'm in talks with a couple different guys. We'll have to do a 40K stream like a weeb stream. Let's see. Under this caption, the SPLC hate map states, hate group members and followers of their ideology sometimes manage to obtain important positions of power. When the city of Baltimore recently hired Glenn Keith Allen, a neo-Nazi, nobody knew of his involvement with white supremacist groups, except for us. Because of our investigation and expose, he was swiftly fired. Thus, the SPLC publicly claims Allen infiltrated the city of Baltimore Law Department with racist and neo-Nazi policies, which the SPLC put a stop to by causing his firing. Full Cosby, the SPLC is a t-shirt I'd buy. Oh, speaking of that, guys, I've set up a Teespring account and should have some shirt designs out like really, really soon. This is not an ad. This is not an ad in any sort of way for anything other than my own t-shirts. But YouTube has apparently partnered with Teespring, and soon there will be a banner running under the YouTube thing where you can buy any merchandise that I create through Teespring. Like, it'll be right there while the channel is while the show is going. You'll be able to see what's out there. And so there's like mugs and shirts and all sorts of stuff. Those are actually coming now. I've talked to my artist, and we are going to be putting them out very soon. So, yeah. But I don't know when the banner will come up, because that's rolling out to YouTubers apparently, and it hasn't rolled out to me just yet. But there will be a Teespring link soon, and then of course once the banner thing is implemented, I'll put that up so it's easy for people. So Fireball T-shirt, there you go. Merriam-Webster Dictionary defines infiltrate as follows. To full Cosby. There you go. To enter or become established gradually or unobtrusively, usually for subversive purposes, e.g. the intelligence staff has been infiltrated by spies. Collins Dictionary defines it as follows. To penetrate or cause to penetrate a region or group gradually and stealthily. So as to attack or seize control from within. The dictionary.com definition is as follows. To pass a small number of soldiers, spies, or the like into a territory or organization clandestinely and with hostile or subversive intent. Allen did not infiltrate the Baltimore City Law Department in accordance with these or any other widely accepted definitions. He did not enter into it secretly or clandestinely with hostile or subversive intent so as to attack it or seize control of it from within. Such a claim is ridiculous. He was hired openly, and the ridiculousness of the claim may actually be the SPLC's defense there. He was hired openly and in accordance with normal procedures by the city solicitor, George Nilsson, an active and prominent liberal Democrat who had known him for decades while both worked at DLA Piper. While in the city law department, Allen was not in a policy-making position, never let political issues influence his legal work, and in fact never even talked politics at the office. He remained loyal to his professional and ethical obligation to represent his client, the city of Baltimore, a city primarily composed of African-American residents and with an African-American mayor and primarily African-American city council. Zealously and competently, the SPLC smear, from which it profited handsomely, essentially accuses Allen of professional ethical violations and incompetence, for which the SPLC had no evidence because it was not true. It was a knowing false statement that the SPLC published through the U.S. mails all across the USA. It further damaged Allen's reputation as an attorney. If you have an educational 501c3, can you make ridiculous claims that could be construed as defamatory with impunity? Apparently so. Apparently so. We'll see. We'll see. The SPLC improperly participated in partisan political campaign activities in the 2016 election cycle. As previously noted, the SPLC, like other 501c3 tax-exempt organizations, is subject to the general prohibition against participating or intervening in any political campaign on behalf of or in opposition to any candidate for public office. That's from the 501c3 code. SPLC has violated this prohibition flagrantly and repeatedly. During the period from October 2015 until November 2016, the SPLC on over 100 occasions publicly attacked the characters and policies of prospective Republican, and only the Republican, candidates for presidents, including the Zodiac Killer, the Dummy, and above all, Donald Trump. That was Ted Cruz, Ben Carson, and Donald Trump. Ben Carson... Sorry, Ben. Kind of a dummy. At least in what you choose to say publicly. A few examples. The SPLC's February 2017 intelligence report, to which Barrich contributed, containing an article captioned "Candidates for President, Other Offices Voice Extremist Views." The article condemned extremist views attributed to 5 presidential candidates: Trump, Carson, Cruz, Huckabee, and Rubio, all Republicans. The SPLC commented, "It's hard to say which Republican candidate's rhetoric is most appalling." The report also stated, among numerous other unlawful and negative partisan political attacks, that from start to finish, the year 2015 was remarkable for the boost far-right ideas and groups received from pandering politicians like Donald Trump. In an April 13th, I don't think I could ever be an actual 501c3 because when I say that Ruth Bader Ginsburg is eating the aborted black babies to stay alive, that might be considered a statement that would be partisan. I don't know. I mean, maybe Clarence Thomas is too. I have no idea. In an April 13, 2016 SPLC teaching tolerance report titled "The Trump Effect: The Impact of the Presidential Campaign on Our Nation's Schools," the SPLC mentioned Hillary Clinton only once, but Donald Trump 27 times, always in a highly negative light. February 28th, 2016, Barrich, on behalf of the SPLC, published numerous statements disparaging Trump and his assumed ideas, including Donald Trump's statements this morning are just the latest in a string of incidents where he has used his massive media presence to elevate extremist ideas and individuals. In a letter complaint that the Federation for American Immigration Reform filed with the Internal Revenue Service, FAIR identified over 113 instances in which the SPLC engaged in partisan political campaigning in the 2016 presidential elections against announced candidates, all Republicans, primarily Donald Trump, and this tally was only through July. See also Stella Morabito, The Federalist, 12 Ways the SPLC is a Scam to Profit from Hate-Mongering at Section 6. Quote, "The SPLC operates far more as a political action committee than as a nonprofit it claims to be. The hyper-partisan nature of the SPLC's operations makes its nonprofit status seem like a joke." See also Carl Zinmeister, Philanthropy Today, describing the SPLC as a notoriously partisan attack group with an utter lack of reasonable criteria for who goes on the list of hate groups. In an IRS Form 990 return of organization exempt from income tax that the SPLC filed with the U.S. mails or electronically with the Internal Revenue Service on or about January 26 when it was signed, covering the SPLC's fiscal year November 1, 2015 to October 13, 2016, the SPLC stated under penalties of perjury that it did not engage in direct or indirect political campaign activities on behalf of or in opposition to candidates for public office. As shown above, this is a knowingly false statement. Next, the SPLC has engaged in unethical actions prejudicial to the administrations of justice. Among a myriad of other instances of violating legal ethics, the law, and civilized norms, the SPLC has engaged in conduct prejudicial to the administration of justice by submitting documents before a judicial tribunal replete with smears, name-calling, and invective. Its favorite approach and one at which it is masterful. In 2015, when FAIR submitted an amicus brief on an immigration issue, the SPLC opposed the amicus brief not with legal argument, but with smears and name-calling, as described by the U.S. Department of Justice's Disciplinary Council letter ruling. Based on the foregoing information, this office is troubled by the conduct of Ms. Cho, lawyer for the SPLC. Her conduct overstepped the bounds of zealous advocacy and was unprofessional. In her motion, Ms. Cho made uncivil comments that disparaged FAIR and its staff. Ms. Cho called FAIR a hate group, anti-immigrant, white supremacist, eugenicist. How can the SPLC call anyone eugenicist when it openly supports whatchamacallit, Planned Parenthood and other groups? Anti-Semitic and anti-Catholic. Oh, wait. Suddenly the SPLC is calling someone else anti-Catholic. I mean, are we serious? None of this language was related or relevant to the underlying legal or factual issues of FAIR's amicus briefs, and its sole purpose was to denigrate FAIR and its staff. Such language is not appropriate in a filing before the board or any judicial tribunal because it constitutes frivolous behavior and does not aid the administration of justice. That's from the DOJ Disciplinary Council letter, dated March 28th, 2016. At the top of the SPLC's 2016 hate map published in 2017, the SPLC states, Southern Poverty Law Center is the nation's leading source for reliable analysis of the radical right. Oh, yeah. With that statement alone, you know it's false. Hate and anti-government extremist groups continue to operate at alarming levels in the U.S., fomenting racist violence, seeking to poison our democracy. We don't have a democracy. And in some instances, plotting domestic terrorist attacks. The SPLC's representation is that it is the nation's leading source of for reliable analysis of the radical right is false and misleading. Among other reasons it is a false and misleading are the following, which have been previously explained. They use illegal means to obtain information. They violate canons of professional ethics. Use self-serving redefinition of hate groups that is inconsistent with the usual and widely accepted meaning. Wildly inflates the number of hate groups on its hate maps. Violates prohibition of 501c3 organizations participating in political activity against a candidate. Engages in tabloid-style journalism and personal attacks that lack even the semblance of objectivity or balance, and tailors its communications for maximum fundraising purposes. Okay. Marsupial Gamer asks, are they trying to get the SPLC's status as a law firm revoked or something? Or does this stuff directly impact this actual lawsuit? He's going after their 501c3 status. That's one of the big things. He's trying to attack their 501c3 status. Also using their 501c3 status as an anvil upon which he is smashing the hammer of unethical and defamatory actions. But yeah, I think he is going after their 501c3 status. We're about to get to the causes of action, and then we'll get the, the requested relief from each one. The SPLC has provided slanted information, which is racist, to the Federal Bureau of Investigation. Why do they... On information and belief, the SPLC provided biased information to the Federal Bureau of Investigation and other law enforcement organizations for many years up to and including 2014, and may have continued to do so after 2014. See this Fox News article. I'm not going to read. Congressman Matt Gaetz, July 23rd, 2018 letter to the FBI demanding answers to questions regarding information shared between the FBI and SPLC. Cause of action. Woohoo! That fact section was long, a little bit boring, kind of tedious. Thanks for hanging out with me through it, because I know this stuff is thick, and not THICC thick. This is the SPLC lady thick. THICK KK. Because the SPLC hates black people. Allen incorporated count 1, declaratory judgment claim against the SPLC. The SPLC status as an assumed 501c3 public interest law firm has contributed and continues to contribute greatly to its ability to accomplish its goals of conducting close surveillance on and destroying Allen and others, in that this 501c3 status facilitates the SPLC's access to media, imparts to the SPLC the undeserved status of a respectable civil rights organization, enhances donations to its already massive operating funds and net assets, and contributes to a general willingness among the public to ignore or excuse the SPLC's violations of the rights of free expression and freedom of association of its victims. Allen has been directly injured by the SPLC's abuse of its status. Among other things, the SPLC's assumed 501c3 status facilitated its ability to generate massive publicity relating to the SPLC's August 17, 2016 article, and thus to successfully pressure the city of Baltimore to fire Allen. The SPLC's assumed 501c3 status has also enhanced its ability to reach wide audiences with its false characterization of Allen as infiltrating the city of Baltimore Law Department in its 2016 hate map. Under Internal Revenue Service Code 4.76.9.3, which defines the public interest criteria a public service law firm must adhere to receive or maintain 501c3 tax status, the organization cannot attempt to achieve its objectives by illegal activity or through a program of disruption of the judicial system. The organization cannot violate any canons of legal ethics, and Allen... oh, that's it. Next paragraph. Allen asserts that the SPLC has contravened and violated the public interest criteria for 501c3 status described in the prior paragraph by, among other violations, those summarized in paragraph 24, including knowingly receiving stolen property, namely the Dillaway stolen documents, participating in the theft of the dildo documents by paying for them or otherwise benefiting Dillaway, multiple instances of mail and wire fraud, menacing with a shotgun, making a false statement on its IRS Form 990, violating attorney-client privilege, engaging in conduct prejudicial to the administration of justice, and violating rules of professional conduct, list of rules. The SPLC disputes Allen's assertions in the prior paragraph. An actual and concrete dispute as to this issue therefore exists between the parties. That's important to avoid summary judgment. If there's no dispute, then there's no trial. If there is a dispute, they have to go through a lot more. The SPLC's 501c3 status is also based on the requirement that it had not engaged in partisan political campaigning. As set forth in paragraphs 117 and 118 of this complaint, Allen asserts that the SPLC has repeatedly and flagrantly contravened and violated this requirement. SPLC disputes the assertions in the prior paragraph, an actual and concrete dispute. This is also for declaratory judgment. For declaratory relief, you have to have an actual and concrete dispute of a factual matter. If you don't have an actual and concrete dispute on the declaratory elements, then you can't get a declaratory judgment. Concrete dispute as to this issue therefore exists between the parties. The SPLC's 501c3 status is also based on the requirement that its actions remain within its educational mission. As set forth in paragraph 94 of this complaint, the concept of education and the privilege of tax exemption impose some degree of obligation for fair balance in its articles. An organization may be educational even though it advocates blah, 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 so long as it gives enough facts. We read that earlier. Presence of any of the following factors in the presentations made by an organization is indicative that the method used by the organization to advocate its viewpoints or positions is not educational. 1. Presentation of viewpoints or positions unsupported by facts is a significant portion of the organization's communications. 2. The facts that purport to support the viewpoints or positions are distorted. 3. The organization's presentations make substantial use of inflammatory and disparaging terms and express conclusions more on the basis of strong emotional feelings than of objective evaluations. Next. Allen asserts that the following aspect of the SPLC's conduct with respect to him and others contravene and violate the SPLC's required educational mission, its avowed purpose of destroying entities and persons it describes or monitors as so-called hate groups or hateful persons, its practice of ritual defamation, its disregard of even a semblance of balance in its August 17 article about Allen, and in other articles it has published about other entities and persons it describes or monitors as so-called hate groups, hateful persons, or extremists, its tactics of orchestrating violations of the constitutional rights of Allen and other entities, and persons it describes or monitors as so-called hate groups or hateful persons. Its manifest primary focus on fundraising, which among aspects leads it to adopt sensationalist supermarket tabloid-style journalism, otherwise known as clickbait, and its massive surveillance operations, which include a multitude of informants and spies. SPLC disputes it. Yeah. Declaratory judgment stating the SPLC's improper and illegal actions as set forth above contravene and violate requirements for its 501c3 status will serve the useful purpose of clarifying the legal relations between the SPLC and Allen. Among other things, the declaratory judgment will restrain the SPLC from continuing to engage in these improper actions against Allen and others. Yes, because if they get this declaratory judgment, then they would be subject to review by the IRS, and they would have to show that they have remediated their bad behavior to maintain their status. Wherefore, Allen requested declaratory judgment against defendant SPLC, plus costs, reasonable attorney's fees, and for other such and further relief as the court deems just and appropriate, that the SPLC contravened and violated requirements for 501c3 status by its following actions. Oh man, there's pages of them. It's all the stuff we just discussed. I'm not going to read it again because if I do, it'll be forever. It'll take forever. Look at this, 3 pages of claims. Count 2, which is like 30 pages. In fairness, it's like 30 pages condensed into 3. But we just went through them. I'm not going to go through them again. Good Lord, it's hot in the vault today. Claim against Barich and Potok. Plaintiff Allen is an attorney. Oh no, why are we doing the parties again? Oh, this is... All right. Plaintiff Allen is an attorney practicing law in Maryland and the District of Columbia. Since December 2015, he has practiced as a solo practitioner. He is a person as defined in 18 U.S.C. 1961(3) of the Racketeer, Influence, and Corrupt Organizations Act, and accordingly is entitled to sue for civil remedies under 18 U.S.C. 1964(c) of the RICO Act. I wonder if Ken White would say this is RICO. Ken White's bias may get in his way. I don't know. He's sometimes good, even in spite of his bias. If the SPLC lists other people as hate groups for promoting hatred of other groups or people, then by definition, shouldn't the SPLC list itself as a hate group? Yes. Yes. Defendant Barich is an individual capable of holding a legal or beneficial interest in property and accordingly is a person. Defendant Potok is an... I don't know. Barich may be persons. Defendant Potok is an individual capable of holding a legal or beneficial interest in property and accordingly is a person. I don't know if that's true either. Kind of looks like a lemming. RICO Enterprise. Enterprise is defined in the RICO statute as follows. Any individual, partnership, corporation, association, or other legal entity, and any union or group of individuals associated in fact, although not a legal entity. Within the SPLC, a subset of SPLC officers and employees, including Barich, Potok, and others, formed and conducted an association in fact known as the Intelligence Project. The Intelligence Project has an ascertainable structure with Barich as its director and Potok as the editor-in-chief of its major publications and continuity over time, more than a decade of structure and personnel. Intelligence Project accordingly was an enterprise in accordance with the RICO definition. Intelligence Project enterprise engaged in and its activities affected interstate commerce among other ways through conducting surveillance across the USA and distributing publications across the USA. SPLC, a corporation that encompasses the Intelligence Project and other special departments and divisions, is also an enterprise in the RICO definition. They engage in and its activities affect interstate commerce among other ways through conducting surveillance and distributing publications. Pattern of racketeering activity. RICO claims are thin, almost always. Barich as a director of the Intelligence Project and Potok as editor-in-chief of the Intelligence Project's publications agreed to and did conduct the Intelligence Project RICO Enterprise and the SPLC RICO Enterprise through a pattern of racketeering activity specifically as follows. National Stolen Property Act. Intelligence Project and SPLC conducted through and by leadership and management of Barich and Potok knowingly received stolen property valuing $5,000 or more that crossed interstate lines, namely the Dillaway stolen documents as described in paragraphs 58 to 67 of this complaint. They therefore violated the Alabama criminal statute prohibiting receipt of stolen property, also the Federal National Stolen Property Act. a RICO predicate act under 18 U.S.C. 1961. The Travel Act. The Intelligence Project and SPLC engaged in commercial bribery of a fiduciary, namely Randolph Dillaway, as described in 58 to 67 of this complaint. Therefore, violated the Alabama criminal statute prohibiting commercial bribery of a fiduciary, also the Federal Travel Act, which is a RICO predicate act. Mail fraud. The elements of a violation of the mail fraud statute are: 1, the use of U.S. mails or a private or commercial interstate carrier for the purpose of executing or attempting to execute a scheme or artifice to defraud. Scheme or artifice to defraud includes a scheme or artifice to deprive another of the intangible right of honest services. As described in 60 to 71 of this complaint, the Intelligence Project violated the mail fraud statute by use of the U.S. mails or private or commercial interstate carriers to attempt to execute a scheme or artifice to deprive the National Alliance of the honest services of Dillaway, who owed its fiduciary duties, thereby injuring Allen as described in paragraphs 96 to 101. Mail fraud is a RICO predicate act. Another mail fraud claim. What is a fiduciary? A fiduciary is someone who owes a duty, called a fiduciary duty, by nature of its financial relationship with an organization. So a fiduciary would be someone put in a position of specific trust that must act in the financial interest of the company and not to its detriment. For example, your real estate agent, when you're selling your home, has a fiduciary duty to you, meaning that if they come across information that would increase your ability to sell your home, like, for example, they overhear a potential buyer saying that they could pay more money, but they're going to offer less. So they hear them say, we're going to offer $250, but we could really afford $275 on this. Then they have a fiduciary duty, a responsibility to you to communicate the fact that they can pay and would be willing to pay the $275, and therefore to advise you to think about rejecting the $250 offer. In this case, the fiduciary would be the accountant, who would be, by nature of his accounting position, privy to privileged confidential documents as part of his accounting that he would then not be able to disclose to the public because it could cause damage to the company that he was working for. To his, it would be a breach of his fiduciary obligation. So I hope that helps you understand what a fiduciary is and what that means. As described in paragraphs 113 to 115 of this complaint, the Intelligence Project violated the mail fraud statute by use of the U.S. mails to distribute hate maps, falsely stating that Allen had infiltrated the Baltimore City Law Department in support of their attempt to execute and their execution of a scheme or artifice to defraud by fundraising based on false statements about Allen at the expense and injury of Allen. As described in 101 to 103 of this complaint, they violated the mail fraud statute by use of U.S. mails to distribute publications across the U.S. intentionally inflating their hate group tallies in support of their attempt to execute to defraud donors by deceitful fundraising. 104 to 108 of this, that's a weak claim, unfortunately. It's true, but as far as the legal claim goes, that one's going to fall out. The one before it probably will too, but, you know, to be honest. 104 to 108 of this complaint violated the mail fraud statute to distribute publications that intentionally used a definition of hate group at odds with its widely accepted connotation, thus falsely attributing violent ideology and actions to nonviolent groups and persons in support of their attempt to execute defraud of donors. They violated the mail fraud statute by distributing publications that contained intentionally false statements regarding Maajid Nawaz in support of the Intelligence Project and the SPLC's attempt to execute in their execution of a scheme or artifice to defraud donors by deceitful fundraising. This one is probably precluded because Maajid Nawaz did go ahead and negotiate a settlement in litigation around the issues where this should have been raised. So this would be issue preclusion under the double jeopardy protections, and is probably going to get thrown out because Maajid Nawaz already litigated the facts at issue. And if there was a RICO controversy, it should have been brought up in that lawsuit and adjudicated in that way. So this one will probably get tossed. Mail fraud, again, to communicate a false statement under penalties of perjury in an IRS Form 990 to defraud donors by deceitful fundraising. Mail-in wire fraud, as described in paragraph 34 of this complaint, by use of interstate wire or mail communications to make numerous intentionally false statements about Charles Murray in support of the intelligence projects and the SPLC's attempt to execute and their execution of a scheme to defraud donors by deceitful fundraising. The acts set forth above constitute a pattern of racketeering activity pursuant to 18 USC. Birch and Potok directly and indirectly conducted and participated in the conduct of the intelligence project, RICO's Enterprises, and SPLC RICO Enterprises affairs through the pattern of racketeering activity described above. By reason of and as direct proximate result of their racketeering activities, Allen has been injured in his business and property. In that he was terminated from his position in the Baltimore City Law Department and his reputation as attorney was severely damaged. He requests an entry of judgment against them for actual damages of $1.5 million, trebled in accordance with 18 USC 1964C, plus cost of suit and reasonable attorney's fees, and for other such relief as the court deems appropriate. So that's up to $4.5 million plus costs. Good job, buddy. RICO 1962 claim against Birch and Potok. Let's see. They conducted the affairs through a pattern of racketeering activity. Inherent in their relationships with these enterprises was dialogue, coordination, collaboration, and agreement between Birch and Potok as to the actions, policies, and values of the enterprises. It would not have been possible for them to have conducted the affairs of the enterprises without this dialogue. Allen accordingly alleges that Birch and Potok conspired with each other and with other persons to violate 18 USC 1962C in violation of 18 USC 1962D. By reason of and as a direct and proximate result of this conspiracy, the overt acts taken in furtherance of the conspiracy and violations of 18 USC 1962D, Allen has been injured in his business and property in that his reputation was damaged and he was fired. Requests another entry of judgment, $1.5 million trebled in accordance with 1964C plus cost of suit. So another $4.5 million potentially. Tortious interference with prospective advantage. Claim against Birch and the SPLC. This is similar to a tortious interference with contract, but tortious interference with prospective advantage, if I'm not mistaken, requires a showing of actual malice as opposed to the lower standard of just basically making the statements. They have to do actual malice, which would be knowledge of the falsity of the statement, similar to a defamation claim against a public figure. Prior to the publication by Birch and the SPLC of the August 17th article, Allen had an at-will contractual employment relationship with the city. Birch and SPLC knew of the at-will contractual employment relationship described in the prior paragraph. Birch and the SPLC, by means of the article, intentionally interfered with the at-will contractual employment relationship for improper purposes or by improper methods, including knowingly receiving and then using stolen documents in the article, engaging in commercial bribery to obtain the stolen documents, committing mail fraud, violating attorney professional ethics, and acting outside the scope of the SPLC's 501c3 mandate. Interestingly, not a defamation claim in there, probably because they don't need it. Also, because their truth as a defense might be bad for Allen. Doesn't matter if it's true, although truth can be a defense in this type of circumstance where when you make the claim based on defamatory statements, when you make the tortious interference claim based on defamatory statements, they can use truth as a defense. When you make it based on these other elements, you eliminate that truth as a defense. Because even if it was true, they did it illegally, right? That's the problem here. Birch and the SPLC's interference caused him damages, including loss of his employment and damage to his reputation. They constituted conscious and deliberate wrongdoing motivated by wrongful motives and ill will. That's the actual malice that they're going for. Demands judgment against the defendants and SPLC in amounts to be determined at trial, but which currently exceed $1.5 million in compensatory damages and $5 million in punitive damages, plus costs, reasonable attorney's fees, and other such relief as the court deems appropriate. Count 5, tortious interference with contract. Claim against Birch and the SPLC. As of May 2015, Randolph Dillaway was subject to a confidentiality agreement covering the documents and other information he examined while an employee of the National Alliance. Allen was a third-party beneficiary of the confidentiality agreement, which means he was not party to the agreement, but as someone covered in the confidential documents, he would be a beneficiary of that confidentiality. That makes some sense. Birch and the SPLC knew of the confidentiality agreement and knew that Allen was a third-party beneficiary. They intentionally interfered with the confidentiality agreement for improper purposes or by improper methods. Now, this is clever. They're interfering with the existence of the contract, the confidentiality agreement, not his employment contract. That was the previous one, but this is interfering with the contract. A third-party beneficiary to a contract can sue for tortious interference with contract if their direct benefit was impacted by the breach, by the induced breach. So this is an interesting approach to TI. It's not too common. You don't usually have the third party alleging the TI. Usually the TI is between the contracting parties, or the contracting party to the infringing party, right? But this one's a little different because we do have a third party beneficiary. Birch and the SPLC intentionally interfered with the confidentiality agreement for improper purposes by knowingly receiving and then using stolen documents protected by the confidentiality agreement, engaging in commercial bribery to obtain the stolen documents, mail fraud, violating attorney professional ethics, and acting outside the scope of the mandate. Their interference caused damages. He's asking for $1.5 million and another $5 million in punitive damages again. So, big money, big prizes. I love it. A negligent training and supervision claim against the SPLC. Birch, as director of the SPLC's Intelligence Project and Potok as editor-in-chief of the Intelligence Project's publications, were employees of the SPLC at all times relevant to the allegations in this complaint. Birch remains an employee of the SPLC. On information and belief, Potok, after more than 2 decades as an SPLC employee, ceased being an employee in approximately March 2017. SPLC, with its prodigious surveillance capabilities, media access, and financial resources, placed and retained Birch and Potok in positions of enormous power over the vocations and reputations of members of the public. Moreover, many of the decisions Birch and Potok were called upon to make or participate in involved momentous legal issues relating to the First Amendment and free expression, defamation, invasion of privacy, among others. In proportion to the substantial likelihood and grave severity of potential harm flowing to the public from Birch and Potok's actions and decisions, must be the SPLC's duty to properly train and supervise Birch and Potok. The duty is enhanced by the fact the SPLC is a law firm subject to the ethical responsibilities to train and supervise its employees, lawyer, and non-lawyer. Training and supervision the SPLC provided to Birch and Potok fell short of any reasonable standard. This is shown, among other ways, by the May 20, 2015 Chaos at the Compound, August 17, Baltimore hires neo-Nazi lawyer articles, both written by Birch, with the evident collaboration of Potok as the Intelligence Project editor-in-chief. Both articles address both explicitly and implicitly, erroneously, and without any evidence of supervision by a lawyer, important legal issues, including disclosure of privileged and confidential documents, alleged justifications for breaching a confidentiality agreement, alleged justifications for invasion of privacy, alleged justifications for defamation, and the propriety of a 501c3 organization engaged in one-sided tabloid-style journalism. As a direct and proximate result of the SPLC's inadequate training and supervision of Birch and Potok, the SPLC improperly received and disclosed the Dillaway stolen documents, including confidential and privileged documents, in the August 17 article, leading to Allen's termination from the Baltimore City Law Department and damage to his reputation as an attorney, and falsely stated in the SPLC's 2016 hate map that Allen had infiltrated the Baltimore City government, thus further damaging his reputation. So he demands an amount currently exceeding $1.5 million in compensatory plus costs and such other and further relief. Restitution / unjust enrichment against defendant SPLC. Allen incorporates the allegation set forth before. A defendant is unjustly enriched and must provide restitution when the defendant knowingly obtains or retains money or benefits that in justice and equity belong to another. This is going to be, in my opinion, a very weak claim that they're fraudulently inducing donations, and I really don't think that hyperbole in public statements by a 501c3 can amount to unjust donations. I just don't think that's a valid legal theory in this case. They have to like so severely distort factual allegations that it has to be misstatements of fact, not just hyperbole. If I had to guess, this is kind of a novel claim. I think it's thin. The SPLC benefited monetarily and in other respects from the August 17 article. By means of the article, improperly advocated and successfully orchestrated the destruction of Allen's career and reputation, and the SPLC arranged for the publication of the article in at least a dozen newspapers around the country and internationally, all of which served to maintain and enhance their power and prestige as a supposed civil rights organization and public service law firm, which in turn served to maintain and enhance the flow of donations and valuable media access for the SPLC. It's going to be really hard to link any amount of donations to this specific article. It is relevant in this regard that the SPLC has kept the August 17 article on its website from August 17, 2016 to the present day as evidence to general public of the SPLC's potent and successful surveillance and its power and prowess in destroying its victims. The benefits the SPLC has reaped from the August 17 article have been at Allen's expense. In justice and inequity, these benefits should be taken from the SPLC and restored to Allen. Among the relevant considerations in this regard are those set forth in paragraphs 122, 123, 125, 129, and 130. He demands judgment against SPLC in a restitutionary amount to be determined at trial, plus costs, reasonable attorney's fees, and such other and further relief as the court deems just and appropriate. You're already covered in hate. Count 8. Defamation claim against Birich, Potok, and the SPLC. So here's the defamation claim. As set forth in paragraph 113, the SPLC hate map published all across the United States, part of the intelligence project for which Birich was the director, Potok, the editor-in-chief, prominently displays Allen's photograph next to the caption in bold, read, exposing racists who infiltrate public institutions. It's going to be hard too. Racism is generally an opinion, unfortunately. Unfortunately, it's generally an opinion. Although, like if truth is a defense, I mean, it's not truth that's a defense. They'll say that racism is an opinion and it is protected, that you can determine someone's actions to be racist or their beliefs to be racist. That would be their defense. This is going to be a hard claim. Under this caption, the SPLC hate map states, hate group members and followers of their ideology sometimes manage to obtain important positions of powers. And they're also going to quibble over the infiltrate. Infiltrate is not a strong, like, the comment. I mean, I know he went through the legal lessons on the definition of infiltrate, but what they mean is in common parlance that he infiltrated, as in he didn't disclose to them that he was a racist and then they hired him. That's the infiltration that they're going to be talking about, and it's probably going to be a good defense to the defamation claim. When the city of Baltimore recently hired Glenn Keith Allen, a neo-Nazi, nobody knew of his involvement with white supremacist groups except for us. And maybe he could say he's definitely not a neo-Nazi because he's not part of any neo-Nazi organization. But they'll argue that his association with the National Alliance would be their basis there. Except for us, because of our investigation expose, he was swiftly fired. Thus, Birich, Potok, and the SPLC publicly claimed Allen infiltrated the city of Baltimore Law Department with racist and neo-Nazi policies, which the SPLC put a stop to by causing his firing. As set forth, the definitions of infiltrate, yeah, I don't think that's going to work. As set forth in paragraph 115, he did not infiltrate the Baltimore City Law Department in accordance with these or any other widely accepted definitions. He did not enter into it secretly or clandestinely with hostile or subversive intent so as to attack it or seize control of it from within. He was hired openly and in accordance with normal procedures by the city solicitor, George Nilsson, an active and prominent liberal Democrat who had known him for decades while they both worked at DLA Piper. While in the city law department, Allen was not in a policy-making position, never let political issues influence his legal work, and in fact, never even talked politics in the office. He remained loyal to his professional and ethical obligations to represent his client, the city of Baltimore, a city primarily composed of African-American residents, with an African-American mayor and primarily African-American city council zealously and competently. The SPLC smear, from which it profited handsomely, essentially accuses Allen of professional ethics violations and incompetence, for which the SPLC has no evidence because it was not true. It was a knowingly false statement. If he's got anything, it might be this, but they don't essentially accuse him of that. I mean, they don't actually say it, right? So that's a trouble. Accusing Allen of being an unethical or an incompetent attorney is defamatory per se. That's true, but I don't know if they did accuse him of being unethical or incompetent. They accused him of being racist. Birich, Potok, and the SPLC published this defamation knowing it was untrue or recklessly disregarding whether it was true or untrue. Birich, Potok's, and the SPLC's defamation further damaged Allen's reputation as an attorney. Birich, Potok's, and the SPLC's defamation constituted conscious and deliberate wrongdoing motivated by wrongful motives and ill will. Glenn K. Allen demands judgment against defendants Birich, Potok, and the SPLC in amounts to be determined at trial, but which currently exceed $1.5 million in compensatory damages and $5 million in punitive damages. Almost done. Almost done, guys. Count 9, aiding and abetting breach of contract claim against Birich, Potok, and the SPLC. Confidentiality agreement between Randolph Dillaway and the National Alliance was a valid agreement. Dillaway breached confidentiality agreement by stealing numerous thumb drives of confidential documents and transmitting them to the SPLC. Dillaway further breached the confidentiality agreement by cooperating with the SPLC and publishing the information in the Dillaway stolen documents in the SPLC's publication. Birich and the SPLC aided and abetted Dillaway's breaches described in the prior 2 paragraphs by receiving the documents, paying consideration to him for them, and then publishing them in the SPLC's publications. Allen was injured as a proximate result of aiding and abetting his breaches. At least they didn't aid and abet his breaches. In the publication of information from the Dillaway stolen documents, the article on August 17th article caused Allen's termination from his employment and damaged his reputation. Again, $1.5 million in compensatory damages and $5 million in punitive damages, plus costs and other such relief. Glenn Allen Esquire representing himself. There you go. There's his address. Don't bother that guy. Here's some evidence. Oh, here's the summons. To Heidi Birich, summons to Southern Poverty Law Center, and the summons to Mark Potok, and then the civil cover sheet. There we go. Woo-hoo-hoo! That was long. That was long. All right, guys. That was a lot of document to cover. All right. So I don't have much more to say. It's a tough lawsuit. Guys on Stream Me have been noting that the SPLC has a lot of power and litigating authority, as well as a giant reputation. That's hard to overcome, especially for judges. The law profession leans left. That means that judges by default lean left. Not all of them. Not all of them. The SPLC has a history of being respected, even though they're out of favor recently among some groups. That history, like the media, right? Put it in boomer terms. Your judge is going to be a boomer or older, and a judge who is a boomer or older has decades of propaganda supporting the SPLC in their minds. All right? Now, what they did here to this guy is pretty egregious, but what they're going to say, their defense is very simple. We didn't pay for those documents. We didn't know they were stolen. They might, I mean, I guess they could quibble over the ethics things. Our stupid non-lawyer employees didn't realize that they couldn't disclose this. But that doesn't amount to a negligent failure to train. Like, that's not going to work. And then this certainly isn't RICO. We weren't racketeering to destroy this guy's life. We found someone who was associated with a white nationalist group, and we reported on it because they're a public figure, and it's a matter of public concern. That's going to be their shield, and they're going to say they didn't know the statements were false. They didn't make false statements. They made statements of opinion, and that they would have to show a high bar of actual malice, which would be knowingly making false statements in reckless disregard for their effect on Allen. That's what they're going to do. But they're going to say he was a public figure, he had a racist past, and we exposed it. We exposed it. That'll be their defense. And it's going to be a good defense, unfortunately, for Glenn Allen. But he is an experienced litigator. He has laid out probably the best case he can. I have to assume it's the best case he can. I'm going to reach out to him and ask if he'd be interested in doing an interview and talking about this. I doubt he'll get back to me. But we'll see. Yeah. We'll just have to see how this goes. It'll be in the news, whatever the outcome is. So as this progresses, I'll cover it. It's in district court, so I can find the documents pretty easy. And we'll see. But all of their defenses is going to be, it's all true. No, we don't. No, we didn't. But that could lead to discovery, which could produce some interesting results. Because they do have to disagree. Like, they have to disagree with all of this. So they can't, on summary judgment, say that they agree with everything. He has crafted it to get past summary judgment and an initial dismissal. So that's good. But yeah. All right, guys. 2 a.m. my time, 3 a.m. Eastern. It's pretty late. I am going to do a summary video on this to do the quick hits on the claims where it's not so repetitive and expository. And then that's that. That's what we got. So thanks for joining me tonight. As always, I appreciate the watching and the interacting. Hopefully you found this educational and informative. And let me know what you want me to cover. Tomorrow, I might be talking about the constitutional amendment that's proposed to eliminate the Electoral College and what a disaster that could be. There's all sorts of good stuff out there. I've got to check tomorrow for updates in all of the cases we're following. I don't think there have been any, but you got to check every couple days because things could always get fired. Jeremy Hambley and Matt Loader, their responses to the joint jurisdictional statement request from the judge are due on the 11th, which is Friday. So I will be covering those as soon as those documents are available. We'll see what they put out. I don't know if they'll have a joint jurisdictional statement or if they will. I assume they will have two opposing statements, and we'll cover those. It'll be interesting to see what the Loader's argument is. It's going to be around that $75,000 in controversy. And it'll be interesting to see Hambley's evidence of his $75,000 in losses. Although he's got a good attorney who's competent, I assume his attorney has advised him on how to prepare for that long before they filed suit. But I don't know. We'll see. All right, guys. Thanks for watching. Hit the like, hit the share, all that stuff. More defamation explanation videos are coming. If you haven't watched those, give them a peek. Very educational, straight to the point. First one is 7 minutes long. They're creeping upwards in length, but that's going to go back down. The longest one is 13 minutes. Mostly they're around 10. So, yeah, the next one will be coming, and many more. And then we'll cover another topic, and so on and so forth. All right, guys. Thanks for watching. Peace. Have a good day. See you soon.